Welcome to Law and Licensing. We're happy to have you all here. Thank you all for coming, and thanks to those who come on a regular basis too. We really appreciate you coming. We are going to go ahead and introduce ourselves, and then we'll ask you to introduce yourself if you're representing an organization. If you don't want to be introduced, that's okay too. So Michelle, let's start with you.
Michelle Bolter, District 15.
And yet again, I am Carol Lear from District 7. You've probably all been here and know that, but I'm saying it again.
Linda Hansen, I'm the chair of the committee. I am District 3, which is Tooele and Juab counties and most of West Valley City.
I'm Angie Stallings, Deputy Superintendent of Policy and Communication and staff to Law and Licensing.
I'm Elisa Ellis, District 12. I represent a pretty large geographical area: Daggett County, Uinta County, Duchesne County, Wasatch County, part of Summit County, part of Utah County. So there you go. This is Scott Nielsen. He is District 13, and he will be here, I hope.
Provo and Nebo.
Yes, thank you.
And we have the amazing Sybil over here, Sybil Childs, who will be our administrative assistant. So is there anybody here from organizations that would like to be introduced? Tina?
I'm Tina Smith with the Utah Association of Public Relations.
Thanks, Tina. Anybody else? Is there anybody else who'd like to be introduced? Okay, you'll be introduced when you give comment. All right, thank you. All right, first thing on our agenda is approval of the previous meeting minutes. Oh, just one thing before we start, too. I guess we've got a lot of things on the agenda today, and so I'm going to be really looking to make sure that we're brief, that we don't repeat ourselves, and that things move along, just so you guys know, because I'm afraid that we may not get through it all if we don't do that. So just a heads up. Okay, approval of the previous meeting minutes.
I move that we approve the minutes from November's meeting, 2017. Do I need to say the exact date?
No, that's good. Thank you. Are there any comments, questions, concerns about the minutes? Okay, all in favor? Aye. Aye. Any opposed? Okay, that's unanimous. All right, we'll go to 2.2, charter school requests and waivers from board rule. Yeah.
Linda, or before, I represent almost all of these charter schools at various times.
So you're going to recuse yourself?
I'm not, but I'd like to hear the discussion, so I'm not going to be voting. I may make a comment or two, or ask a question, but I'm not going to be voting. Thanks.
Okay, thank you. Angie, we're going to turn the time over to you.
Just thought I'd give a little bit of background before we ask each of the schools to come up and maybe present their request for waiver. As you may recall and remember, we have a board rule R277-121, which allows schools and school districts to request waivers from our board rules. And we've got 4 schools here today, and I've got them listed above, and they're on board docs that are requesting waivers from either.
Can you guys see those? We probably need to turn. One of you guys see if you can turn that?
Oh, that's there
too. Can you see it over there? Okay.
From the time requirements, the 180-day requirement in R277-419, and also
Thank you, Dave.
some of the graduation requirements in 700, specifically the PE and art requirements. So the board has the authority to waive these requirements, and I think each of these schools has prepared backup documents to support their requests. One thing that I don't think we've communicated to the schools, and I just want to let board members know, in the past, we've generally had waivers of agreements that we will have drafted before they come to committee or shortly after. What I hope we will do is, after the committee has considered these waivers, I will work with each of the schools to develop an agreement that just memorializes what the waivers will be, the time period, so that we can then have that for our records to give to our finance people as well as our teaching and learning people, that both the school and USBE will have as a record of those waivers. So, and then we'll have that ready for January to just add to the board's report or the committee's report when it's submitted to the board for final approval.
Angie, I actually read in the bylaws that we can just have a conversation, don't have to go through the chair in a committee every time.
Yes,
So
but we
just
would prefer to do it that way.
And so I'm just going to ask Angie a question. I just wanted to make sure that that agreement includes a report back.
Yes.
And I would prefer annually, just so that we know what's happening and what the consequences are, because I've seen those waivers with school districts, actually where the school districts themselves because they've had to self-evaluate, change their minds. So.
Great. And actually the rule that we adopted, it was recently adopted this last spring, summer, and then has been enacted since August 7th, actually requires an annual report. And two things that I was actually thinking of yesterday is I think it would be good for us to start posting these waivers in one place on the website so that the schools, board members, I think what happens is oftentimes we have staff turnover, unfortunately, and people don't necessarily recall a waiver that might have been granted 2 years ago or 3 years ago. And so I'm going to work with our IT people and see if we can't get a new section posted. It would be here under the law and policy page. Oh, I picked the wrong page. Okay. But to start posting those waivers, and then we can start scheduling these yearly reviews and making that clearer. So.
Okay, thank you. Mm-hmm. Let's start with UCAS, Utah County Academy of Science. They want to come forward. And just let us know who you are.
Sure. My name is Anna Trevino. I am the principal of the Utah County Academy of Sciences.
Okay. And so could you present your waiver request to us and just let us know exactly what your, we have all the documents here, but for those, especially those listening at home.
That's fine. I'm wondering if you would want to have,
there you go. Just push the button. There you go.
the one that says push. Okay.
Nope, the other way.
Yeah. There's a little red circle on
I can see that. Thank you. I'm wondering if you would like to also have Itinerus come up with me, because we are the two that are asking for the 180-day waiver, but the 990-hour.
They looked very similar. So
yes,
if you
would that be all right?
Itinerus, do you want to come up at the same time? If that's what they'd like to do, that's fine with us.
We're friends.
Yeah, good.
So just push this one.
Yep, just one time.
Just tell us your name and.
My name's Renee Edwards, and I'm the principal of Itinerus.
Thank you.
So we are in a unique situation where we have very innovative, successful early college high schools. Our students attend the high school program and the college program concurrently. So our students are not only just taking high school courses, but they are physically going over to the universities where we're located and taking classes over there on their campus with the regular college student. We have our our partners, our university partners, are changing their calendars to go to more of a 4-day week, where classes are held on Monday and Wednesday, Tuesday and Thursday, and then Fridays are held for either longer lab classes or research courses for students that would then impact our students, because our students go Monday through Friday. We could not align our hours with them if we stay with this program that we have. So what we're asking is not necessarily to get rid of the 990 hours, but to continue having at least 990 hours, to have our students go Monday through Thursday to the courses both at the high school and at the university. And then on Fridays, our class our schools would be still open for seminars or for field trips out to the industry, for study halls, for group study, for help from our teachers that we would then have there on those Fridays. We would like to look at not having our students go after the colleges are done in May. They typically are done the first week in May, and we're done 2 weeks later. The reason why we're asking for that time frame is because that time frame allows for students that are taking summer courses or that want to start a university full-time program after they graduate to have that option rather than having to come to the high school and then going off to those other classes as well. Renee, is there anything else you want to add from your school?
Excuse me, we're similar, but Salt Lake Community College is our partner. They're also moving to a block schedule, which will be Monday, Wednesday classes, Tuesday, Thursday, and Friday, Saturday. So we don't anticipate not holding class on Friday for our high school students. Those in college would still be aligned with their college classes. We have some students on campus as well, mostly their senior year. Junior year, most of the students are at our school, taught by our instructors who are adjuncts for the college. But we still try to keep the same minutes and time in case they need to go over and pick up a class. So we also have a similar problem in May where the students are in a full high school schedule. They wrapped up their state testing, most of the curriculum's wrapped up, and they're starting their high school or their college experience and trying to balance, up to 9, even 10 credits of college with a full load of high school. It's very, very stressful in May. So by us being able to end sooner would allow them to have a better, more successful start in those college classes.
So you're planning on having the students take the assessments before they're done, right? Because that was one of the questions, how you were going to, with the waiver, how you're going to be able to handle the assessments.
Yeah, AP testing is done the first week of May, and the end of state tests are done before then.
Okay, thank you.
Us as well.
Nana, have you had 180 days when you've been ending in mid May before? Have you always had it?
Yes, we have.
And and then secondly, if you have students just work with teachers but not like officially attend class on Friday, would you be able to track that interaction so that
yes,
the later the board would see that? Because that was an experience I had with school districts who said they would do the same thing, and then often it just kind of turned into a Saturday. So.
Right, I agree. We do have, in fact, right now we have before school and after school tutoring that we track our students so that we can see who's coming, who's attending, what assistance they may need, and then if they're coming and they're doing all of those things and still not reaching the the levels that they need to, then we put another step of intervention in there.
Kind of another aside, not just because I work with some of these schools, but I think that this model of charter school is such a good model where you have the school districts working with you, you have a partner who's a university. It just gives a lot of substance and support to the schools. I've watched them for 15 years, and you've been really great schools.
Michelle?
Thank you. So it looks to me that where you're going to not have the 180 days, you're going to have the 990 hours plus.
Absolutely.
Is what it sounds like.
Yeah, right now, I mean, even with, right now as it is, we have over 1,300 hours. And that's really quite a lot for these kids to do. It's very stressful. If we cut back from those 2 weeks that we're anticipating, we'll still have 1,034 hours. So we're still going to be well over the number.
Okay.
Okay, are there any other questions? Yes, Angie.
So related to a question that Chair Hansen asked, specifically, some of our staff were wondering about our end-of-level statewide assessments for grades 9, 10, and 11, and whether any of this would impact your ability to provide those statewide assessments or the ACT.
Sure.
And do you see any need for any kind of accommodation with that, or you anticipate just being able to move forward?
Yeah, actually, we're 10th through 12th.
Oh, okay.
That's us too.
Okay.
And at Itinerus, we've paid every single year for juniors and seniors to take the ACT. We, of course, administer the junior level ACT. That's in February. And for seniors, we pay, that's part of what we do as a school, is pay for them to take the ACT. And they usually do that in the winter time, so well before.
And for the 10th grade SAGE or whatever, in the next coming
Correct.
years, you know, we're going to have a potential new 9-10 assessment. You don't perceive any problems with being able to meet those assessment?
Not at all.
No.
Great.
Yeah.
We just wanted to make sure if there were going to be
Absolutely.
accommodations needed, we address them in the agreement.
Thank
So,
you.
Yeah.
Yeah.
We're talking about second or third and fourth week of May really is where we're dropping classes.
Yes.
Okay. Are there any, if there's nothing else, I need a motion, guys.
I move that we approve the waiver request for UCAS. Sorry, there's so many things listed right here. UCAS and Itinerus, is that how you say it?
Correct.
Yes.
Schools.
Okay. Is there any other discussion? Okay, all in favor? Aye. Any opposed?
We have the minutes show that I abstained.
That you recused yourself.
I'm not recusing myself, I'm abstaining.
Okay. Because you have a conflict. Okay. All right. Thank you.
Do you want us to stay when the other two come up for the next?
No, you could.
part,
I think we're done.
Say one other thing. Would you two be the two that I should contact about working out a charter agreement, the waiver document? Okay, great. So we'll plan on doing that in the next week or so. If that's okay.
Okay, thank you.
Okay, so next we have Ames. And let's have Ames first, I guess. Hey,
I'm Brett Wilson, principal of the Academy for Math, Engineering, and Science.
Hi, Brett.
Good morning.
Would you explain to us your waiver request?
Well, the reason we've asked for this specific waiver is we're a little bit different in that we rent space from Cottonwood and Granite School District. With the two pathways we have in computer science and robotics, I am offering more STEM classes that I actually have classrooms to place them in. So I'm rotating those STEM classes. The reality also is we are asking our students at the current time to do 3 classes if they have the availability to do health, financial literacy, and PE in alternative ways in taking classes so that we can get through the 27.5 credits that we require, as well as up to the 60 hours of University of Utah credit that students can attain while they're at Ames. Our board of trustees, in cooperation with me, want that flexibility to be able to do that for the students that are on those tracks. And that's what we're representing today for us.
Okay, are there questions? Okay, everybody's probably read through the materials, right? If not, we can go ahead and take a motion.
I move that we approve the waiver for Ames Charter School.
Okay. Is there any further discussion? Okay, all in favor?
Aye.
Aye. Opposed?
And I abstained again. Thanks.
All right, thank you. That passes unanimously with one abstention. And we will now go to Intech Collegiate High School, ICHS.
My name is Jason Stanger. I'm the Executive Director of Intech Collegiate High School.
Hi, Jason.
And our waiver, as you see, requests a waiver of graduation requirements, reducing the art and PE requirements, similar to what you've heard before. We're an early college high school with a STEM focus. And this will allow us to spend additional time with students in STEM areas and early college or college preparatory courses, and expand our pathways in CTE, as well as accelerate students in their college coursework.
Okay, any questions? Yeah, Elisa.
I am curious if you offer those courses for students, but not require it.
Yes, we'll still continue to offer them
Okay.
because, as you can see, we're still requiring some art and some PE, so there'd still be the option to do that. Additionally, students through the early college program have, some of them have opted to do some of these things, take symphony and theater. They actually get a more robust experience
Right.
if that's their chosen path at the university.
Another question too that I have. Have you, are the parents in support of this?
Yes.
Okay.
And Jason, are you, is your request more like Itinerus and UCAS, or more like Ames?
Well, more like Ames, because we're only making one request for a waiver.
And I just forgot. So
Yeah, only for the graduation credits.
Not for the time.
Not for the
Right.
time.
I think ours might be dissimilar, just a little bit more of a reduction in PE. It's a full credit reduction. That will allow us to do more CTE. Right now, we're one of the smallest schools, and so hiring personnel to do things is a challenge. And being able to offer full CTE pathways is one thing we're after. We already have one pathway. We have two more we could complete if we could fit it in the schedule, and that's a challenge.
So you wouldn't require any PE for
No,
graduate?
we would require half a
Half
credit
a
of
credit.
PE and of course the health, and a full credit of art. So
Thanks.
a credit of healthy lifestyles, a credit of art.
Thank you.
Okay. Any other questions for him?
I guess I have a, so you require it, but I guess my mindset's a little bit different. Zion, do you ever allow parents to waive that, say their child's doing things outside of the school, or?
Yes, we do have independent study, PE and art, that students do, and we award competency-based credit for that.
Okay.
And that will continue to be an option as well.
Okay. All right. Motion.
I move that we approve in-text request for waiver from graduation requirements.
Okay. Any further discussion? All in favor?
Aye.
Any opposed? Okay. That's unanimous of those who are voting.
And a civil rights.
All right. Thank you all for coming. We appreciate you. Okay. Now do you want somebody to take it? Okay. Yeah, R277613, LEA bullying, cyberbullying, hazing, and harassment policies and training is back again.
Yes, it is. So, and you can see we've got Corby Eason and Carol Anderson here, and they can introduce themselves too. When they start talking, and remind everybody what their role is. But I wanted to just tell you what's happened since our last meeting. We met with the Bullying Prevention Working Group. That's the name I give it. I'm not sure what its official name is, but it's this Law and Licensing Committee's working group, huh?
Sorry, I said long-standing.
Yes, that's right. And met with both board members Lear and Ellis, as well as board member Vice Chair Warner were in attendance, staff, and we worked on what was revision 3, and that is uploaded and is available after the committee meeting. Part of the revision 3 was to include the addition of employees throughout the rule in different places. Some of the feedback we received from superintendents, from board member Lear, who she had received some feedback from some attorneys in the districts, is that it would be cleaner to separate the employee issues from the student issues. And so the biggest change from 3 to 4 is the elimination of employees kind of sporadically throughout in the bullying provisions, and instead the abusive conduct provisions are now included in one section at the end of revision 4.
So you haven't added anything or taken anything away. You've just moved things around.
Just move things around.
All right.
Yeah. So it's the same language that was in revision 3. We've just moved the references to employees to kind of address the student issues and the employee abusive conduct issues separately. Yes. So revision 4 includes that change, and it does look like a Christmas tree. So you can see the magenta, light blue, blue, red, green. Those are all the changes that were made since last month. So, and I don't know.
Okay. So it's my understanding that the committee met and everybody was in agreement on revision 3 at that time. Right.
And my thoughts since then have changed, having talked to some LEA folks and some attorneys who work with LEAs. And what I concluded is probably happens with some rules that are developed by committee, is that we over-processed this and over-baked it, and that there are many LEAs, if not all, that really need a model policy, but they don't need primarily the lines 262 through.
Are you on revision 4?
I'm in 4, and so I probably have the wrong number. You're right.
That's the right one.
Is that close?
That's the right one, 264.
Yeah, 264, yes, I said 262. So I think that my druthers would be, and I guess I would like, rather than passing something out that we haven't had time to process one more time, that I'd like to have one more meeting with the committee and have a discussion of just simplifying the rule. Primarily taking out that section, but and then putting more emphasis on the model policy, which is, I think, what would be really helpful for LEAs.
So let me understand, and maybe this is not part of what we're talking about here, but one of the reasons that we were working on this rule was because there was concern among LEAs that they didn't have a similar definition of bullying. So they were making reports, as they were required to do, but everybody was reporting bullying differently, what was bullying and what wasn't. And so the ones who were reporting more incidents of bullying thought that it made their LEAs look not as good as those who considered bullying something a little bit more aggressive because they weren't reporting the same things. Am I being do you understand what I'm saying? So they were reporting two different types of bullying. So some LEAs were saying only the severe stuff is bullying, and some were saying all of this harassment and everything else is bullying as well. And so the ones that were reporting all the harassment issues were getting told by their constituents and others that their bullying was worse that it appeared worse than everybody else's because they were using a different standard, basically. And so LEAs asked that we put in this rule a specific standard that they were all meeting the same standard, right? So have we accomplished that?
Go ahead, Corby.
Yep. My name is Corby East, and I work in the Student Advocacy Service section here at USBE. I will agree with Chairman Hansen that the definition of bullying is interpreted differently across the state and also within LEAs, students, and parents. The fact that no one interprets the definition the same. And I think we have to get on the same page as a community. Everyone understand what is bullying and be able to define bullying and be able to report it accurately.
Yes. And also, we've been working with Aaron, and yes, you're correct in those statements, Chairman Hansen, because we're also really looking at improving our reporting, our incident reporting around behavior, not just bullying, but prohibited behavior. And we have met and really looked at part to assist those LEAs with that reporting and being consistent, is really looking at what the CRCD, so the Office of Civil Rights Data Collection looks at, and really then also aligning what they're requiring our LEAs to do from that level to what we're doing here in the state of Utah to help clean that all up and make sure we have really sound data collection that represents fully what's happening. So LEAs are not feeling like maybe they're being targeted for things they're reporting that others aren't. So to come in line with all of that.
Okay, thank you. And the things that I suggest that I would like to look at again are not the bullying definition, which would be the consistent piece, which would still stay consistent. I'm more looking for procedures that might vary from district to district, LEA to LEA, and then also just going through the rule one more time and saying, are we really Are we overproducing this for what would be helpful in the field? And maybe, and my druthers would be to put the emphasis on training and the model policy.
Great. And I agree with that. And we've heard from several LEAs around bullying, and then also some of our discipline policies related to 609, that they really do want us to have a focus on some model policies that would assist them in the field.
Okay. Yes, Terrell.
Thank you for letting me crash your party here. Do you know when we would have that model policy available?
Yeah.
As soon as we can get the rule in place, then absolutely that would be a priority for us as a staff to look at getting the model policies in place.
And I've talked to Carol about this. I have a couple of concerns still with this whole section being in. And again, as I've explained,
is it the same section that Carol talked
264.
about? Okay.
My concern is that we're expecting administrators to be investigators. And I know we've changed the word to review, but when we're asking them to look at social media, text messages, for most of the social media sites that kids use today, if it's not dumped in a certain way, and I use the word dumped because that's what we do, if it's not dumped or preserved in a certain way, it's gone. And if we need to preserve it for a criminal case, it's gone because of an administrator not perhaps knowing how to dump a phone. And so I'm kind of worried about that part still, that we're expecting administrators, we're bringing the criminal justice system in, and that administrators are expected to be investigators with no trigger or no mechanism to let law enforcement know. So there was an incident in bullying where a young girl was in the hospital this week. Law enforcement, at this point, not sure if law enforcement even knew. The teachers didn't know, and it was a pretty serious bullying incident. So I agree we need to get this, we need to move on it, but I'm also worried about not having a mechanism to letting law enforcement know. So if we could figure those two things out.
That would be a good discussion for us to have at that next meeting, because what we have to consider is also the changes that have changed to the Juvenile Justice Code,
right,
and House Bill 239 to be exact. Because if it is a bullying incident, like a parent calling up and saying, I feel like my child's being bullied, at that time, if a school administrator calls the police, they will most likely not come and respond to it. So I'm thinking maybe those are some points that we could put out as part of in the policy and training to address some of that to administrators, because they will have to answer to that parent concern and be able to say, I need to review this incident. I understand the point of going into criminal, but until administrator at that level at least reviews a situation and say, yes, I do think this goes above and would fall into the misdemeanor offenses that law enforcement will address now on our campuses, because what we're even hearing in the field is some of even those maybe assaults that we would still consider assaults. What I'm hearing is police officers aren't even responding to those and taking them as cases into juvenile court.
And it's my understanding, from my own experience with my kids, there's a lot of minor cases of bullying that wouldn't rise to the level of law enforcement that school administrators review and they just take care of. Right. So are we in agreement? And I'm going to ask Elisa, because she's on the subcommittee too, and she has been very quiet over there. Are we in agreement that we need to have another meeting before we take action on this?
I think so, and I also wanted to talk about line 334, and I'm trying to remember what the verbiage was before we added sex, gender identity, or sexual orientation, because I liked it better the first way, but I don't remember. There was a snowstorm, and so the last meeting I got as far as the first Park City exit and turned around, and it's not as productive when for me as a board member, I don't feel like my voice is as representative when I'm on the phone.
Yeah. So I'll address your issue. So the language just said, as you can see on there, it just said the number of incidents included that included a student who's part of a federally protected class. The issue came that our definition of federally protected class actually included, let me get up there, sorry. Hopefully I'm not making everybody sick by driving. If you look at our former definition of federally protected class, those classes were included in there, gender identity and sexual orientation. That's currently in our rule that's there. What we decided as a committee and what was raised to us is that gender identity and sexual orientation, it's not clear whether those are federally protected classes for students. There's more case law for adults. And so instead of including it in the definition of federally protected class, we decided to, when they're reporting, to report the federally protected classes, but also in addition to be able to track if they were bullied, cyberbullied, hazed, or retaliated against based on those things, including sex, gender identity, or sexual orientation. Because if you remember, staff felt like the data information was important because we do get reports that some of the bullying is based on that, but we're not necessarily stating that it's a federally protected class. So this is for data. Is that correct, Corby?
Yeah, then also that is part of the
And I have concerns about the data part.
civil rights data collection.
OCR, yeah.
It specifically say allegations based on sexual orientation. And so that's a federal requirement that we have to collect that data.
Well, and I think one of the concerns too is that the federally protected class definition is a moving target.
Right, and that's
it's
why
go back and forth,
right,
depending on who the president of the United States is. So if as these folks say that there is significant bullying with those students, I think for me it would be important to include that so that we would be able to know if that's true based on information we get in Utah.
Yeah.
Is there anything else that we need to discuss with this group, or is it other things that need to be discussed with the other group?
Right. I think it would be good to have another meeting. And I just want, because this is public, just to state, I don't want any children to be bullied so that doesn't get mixed construed. I don't think any child should be bullied in any situation or instance. And so I don't want this discussion to turn into something that's not.
Okay. Angie.
Just one thing that I thought would be helpful to raise, and that hasn't come up yet. I met with the superintendent, some of the members of the Superintendent's Association on Wednesday, and AG Dave Thomas was also there. And one of the questions was their reaction to this whole section that you all are considering eliminating and the pros and cons of keeping it in. One of the superintendents actually were okay with this rule as is, with this section in there. And one of the point blank questions that Terry Shoemaker asked Dave, I'm talking about 262, this whole section 6. The point blank question that Terry Shoemaker asked Dave Thomas, is this going to give us more liability? And Dave Thomas actually explained how having this standard in rule limits liability, because if you don't have a standard of what a review or an investigation should be, somebody could say that the investigation should have been much broader, much larger, and they could actually have more civil liability than if you have a standard. I don't know if you want Dave to take time now, or maybe it's with the group to explain how, in his experience with higher ed, having a standard actually reduces the liability than keeping it broad open, because you could have a case or a student or a parent sue the district and say, the fact that you didn't do an exhaustive search of all their social media and all of this, that you didn't meet with, 10 witnesses, that actually it could bring on more liability not having a standard. So that's just, I think, a perspective that some maybe haven't considered.
And I think that's a good discussion for the committee, because that cuts the other way too. I've had many cases where parents have said, well, in your rule it says you will do A, B, and C, and you didn't do B because that case didn't lend itself to B. It wasn't kind of inapplicable. So I think that cuts both ways. But I think that's a better discussion to have in the small group. And then also I wanted to say one thing as it relates to Terrell's concern about law enforcement. That cuts the other way too. I think that investigators in the school system have to make a decision in the moment. Does this kid come back to class tomorrow? Where the legal system gets to sort of decide, is it a misdemeanor, is it a C, is it a B? And so I think that just bears, I don't have an exact feeling about that today in the moment, but I think it's really important that we discuss that in the group, because I think that the HB 239 is changing the landscape. But I just want to make sure schools have adequate protection's not quite the right word, but they have adequate controls of their situation.
Hey, we're gonna go to Dave Thomas now.
No, as long as you're listing things to consider, and I certainly agree with what Board Member Lear is saying, but the other thing is to shift the emphasis over to a model policy and to training. I think is a little bit problematic too. I think we need to address considerably more in the rule, because a model policy is merely a model policy. Whether they need to follow it or not, slavishly follow it or not, is also a matter of interpretation as to how they finally put their policy together. I think if you give firmer direction, it need to be done by rule rather than by a suggested model, because the model may or may not be followed or may not be completely adopted. And now if you're going to require that they adopt the model policy as written, then I think that becomes more of a rule than it does as a matter of policy. So I think that's something that needs to be considered as you work through that.
Okay, if there's no objection, well, do you have one more comment?
Yes.
Okay.
And reason that I see it beneficial to have 264 in, because myself and the other staff member here get phone calls from parents, and they are concerned and they feel left out of the review process of a bullying incident or alleged incident, and they would like to know what is happening, what is going on, and they are not clear with their policy at a local level, and they are concerned what do they do and how do they proceed. Or if they do say something about it with a kid, would they get retaliated against? I know the rules say it protect them, but the parents may feel that if I do say something, my kid or myself will be punished because I brought their attention that the local policy is not clear on how they handle alleged review of a alleged bullying incident or hazing. And so it would be a good thing for parents to see the steps and process of that review.
That's why we need to discuss it in another committee.
Without objection, we'll just go ahead and let you guys meet again. We won't take a motion on it this time around. But just I was going to say, let's get it right, but let's also make sure that we get it done within the next month or two. So, okay, thank you.
Thank you.
Yep, thank you.
Thanks, Terrell. All right. Let's go to R277, 482. Yeah, charter school timelines and approval processes. Angie.
Thank you. A couple of months ago, and probably more months that I'd like to admit, the board leadership, state charter school board leadership, and their executive director and I and Scott Jones were called to the Administrative Rules Committee to talk about some questions in our R277 482, so the rule that we're looking at right now, and why for satellite schools we require the school to have been in operation for 3 years before they can apply for a satellite school, but don't give similar guidance for expansion requests. And so the question was whether that 3-year time period should be there or not. Also, the question was, how does a charter school that wants to seek a request for an expansion or for a satellite school know what the board will be considering when they determine whether to grant that request? The hard part about this is that generally our administrative rules are not meant to govern the board. We don't want to say the board shall grant a request or shall grant a satellite or an application if these things happen, because the board rule is not meant to govern ourselves. It's meant to govern LEAs, authorizers, those in the system that we govern. And so what I did is worked on a draft where we could set an expectation by asking an authorizer when they're determining whether to, at the first step, grant a request for an expansion or satellite school, to include the information and consider these items as part of their review, because this essentially is a message to those schools that these are the same things that we as a board will be considering when we determine whether to grant a request for expansion or a satellite.
And so this is R277-482 revision 1. Is that right?
Yes, revision 1.
Okay.
So the reason why there's a revision 1 is after essentially the first draft was kind of a first step at some things that I had heard from members of our staff, from board members, based on committee discussions that we've had over the last couple of years, things that I had heard board members say were reasons that they granted or didn't grant requests. And then I received some additional feedback from our staff, as well as superintendents and others, about other issues that should be included. So essentially the things that we'd be asking the authorizer to consider is the amount of time, and this all starts on lines 151, the amount of time the charter school has operated successfully, meeting the terms of its charter agreement, giving preference to schools that have been successfully operated for 3 years or more, the academic performance data of students at the charter school, giving preference to those who have performing on standardized assessments at or above the standard established in their agreement, their charter agreement, and the average academic performance of other district and charter schools in the area, the financial position as indicated through the annual financial report, annual program report, and audited financial statement, whether the school has a waiting list, the adequacy of their facilities and local infrastructure, student safety issues, and their ability to meet state and federal reporting requirements. So that would be, and then it asks the school to provide that information to the authorizer and the board to accompany their request.
And my concern about that, Angie, and well, I'd like to have a bigger discussion about the purpose of rules, because I think the First Amendments to the Constitution tell the government what to do. So I don't think there's any problem with having in rules direction that provides fair notice to those who outside the board what the board will do. I think that's only fair. That's part of, I think, what a rule should do. But that's a bigger discussion. So I don't have a problem with putting in the rule what the board will do so that there's fair notice to others. Secondly, and that was, I thought, something that came and went with a previous board, and we haven't had any discussion of that, so I'd really like to. The second concern I have, though, is we don't have control over all the authorizers. There are authorizers who are higher ed institutions. There are authorizers who are, and I know this is sort of one of those issues of, but ultimately we're the board and we can approve these or not. But I don't feel comfortable telling an authorizer that's not under the direct supervision of the board to say you shall. I'm also not really comfortable, even though an authorizer could be a school district, but and authorize charter schools. I guess I would rather just directly say these are the standards that the board will review for these things, rather than the more circuitous route. So that's, again, my feeling on it generally, but I think it bears more discussion.
Angie?
Just one clarification. The statute does allow or require expansion requests or requests, and it's kind of a hard issue to determine how this works with other schools, other chartered entities, because all chartered entities, if they are going to expand, are required by law to inform the board of an enrollment increase. And to some extent, I guess there is a question about whether
inform equals approve, maybe.
Yes, and I'm just reviewing, and I've got the statute right up there, so we could all look at it together. But
should we be able to read writing?
It doesn't talk about a charter school and who they're authorized by in this section. It talks about that an increase in enrollment capacity is submitted to the board prior to October 1 of each year. And
so we're the ones that approve those.
but I do think that we can, and maybe somebody will challenge, and maybe that's what you're doing, is challenging the board's authority to request that authorizers of all types consider this when they're determining. I think I could argue that we have the authority to ask them to consider these things as they're determining
We're
those.
not asking them to consider, we're saying shall.
They shall consider. It says shall consider.
Well, shall consider is sort of a mixed message. I guess I'd just rather, and I'm not challenging the board's authority. What I'm saying is I think that the issue bears discussion because it goes beyond this rule, rather than just assuming we won't put any requirements for the board in rules, because I think that gives notice to the public about what standards will be met. And I think that's a fair message to the public and parents and teachers. So I think that's something that bears greater consideration. And in this specific instance, rather than being circuitous, I would rather be direct.
Michelle?
In the code that Angie's got, it says on or before January 2017, in accordance with the Utah Administrative Rulemaking Act, the Board of Education shall, after considering suggestions from the charter school authorizers, make rules establishing requirements, procedures, and deadlines for an expansion of a charter school. So is that not what we are doing?
Yes.
Right.
Okay, so it says in code that that is what we shall do.
But it doesn't, this code predates authorizers of various kinds, and maybe it'll be cleaned up in the great recodification of time. But
I don't know, but that's the way it is now. And so I actually think this helps everybody, because it helps everybody know what the expectations are. And so I think it helps the authorizer. I think it helps the charter schools. I think it helps us. I think it's kind of a win-win. So
I'm also concerned with, my druthers would be to not make the 3 years a preference, but if the concern is that because the reason that those 3 years were in there for satellites is because the satellite schools have escaped the more careful scrutiny of being authorized directly by an authorizer. They become kind of extensions and then extensions and extensions. And so I'd rather apply that to expansions rather than turn it into a preference for both.
Yeah. Oh, Elisa.
Chair, I'm just wondering if we have any public comment on this.
We have 3 people that have signed up for public comment, but I think they all left.
Oh.
So I don't know, Royce or Tina, if you would like to.
I'd
Royce,
like to
come on.
hear what they have to say.
Who else was signed up?
The charter schools, Anna, Brett, and Renee. Mm-hmm.
Oh, okay.
Royce Van Tassel, Utah Association of Public Charter Schools. I appreciate having greater clarity on what the expectations are. In that regard, though, I'm a little concerned that the statement about community infrastructure may be a little bit vague. Historically, that question has revolved in some ways around traffic, and the legislature has tried to identify some specific processes that the local government and the proposed charter school has to evaluate and identified sort of communicate early, communicate often. Angie, you probably drafted that bill a couple years ago. But this somewhat amorphous term, it's not entirely clear. If, for example, you are proposing to do a satellite campus, that's a fundamentally different question than are we going to put additional students in that. And just want to make sure that we're clear what that may look like, because that could run everywhere from sewer capacity or water capacity to
let's say roads.
To transportation. Sure.
Just for
but it's just not abundantly clear, and so having some clarity there is probably valuable.
What about the word, Royce, can I ask you a question? What about the word adequacy? Is that, does that send you a clear enough message, or?
There is a great deal of flexibility there. How one would nail that down in a rule here is really hard for me to figure out. That's frankly why you have plan review and various engineers that are evaluating what the building's capacity can be.
Thank you, Royce. Yeah. Angie.
I think that maybe by putting this, though, into the authorizer's hands, it sets an expectation, too, that if there are infrastructure issues or facility issues, that those be brought to the attention of the authorizer, because I think what we've seen in the past is some of these issues aren't brought until it comes to the board level. And so it's not necessarily meant to be, it's hard to describe what those issues are, but I have heard in times where schools have presented in the past where all of a sudden board members are hearing about transportation issues or safety issues of students for drop off and pickup related to the roads and where they're placed. And if we're going to consider those, it'd be great to be able to have the community know, why don't you bring any infrastructure transportation. I actually recently heard of a school, I guess, that's in Heber City that opened that is having sewer problems. And so those are related to the facility, and maybe it's not quite Heber City, but it's in that area. So that's where this feedback is coming from, is for them to consider all of that and work with their schools on that before it comes to the board.
And it's kind of giving them a heads up that we may ask about those kinds of things, right? Yeah.
I'd like, though, these, one of the kind of elephants, many elephants in the room that's being ignored is I understand what you're saying about wanting to leave it to the authorizers, but I think ultimately the board's responsible for this 11% of the students that are in charter schools. So I don't think that we can just say we want to leave it to the authorizers or send the parents to the authorizers or send the complaints to the authorizers. I think that the board either has to set very prescriptive standards, which I'm not prepared to do either. I'm not crazy about that. I don't know how we would even do it. Or we need to work out how the authorizers answer to the board in a more clear. That's my feeling about it, because I won't turn away parents who come to me, because I know I'm responsible for those 11% of students, just like I am the other 89%. There we go.
Okay, so we're at the point where we need either a motion to approve this as is, or we need a motion for amendments.
I can't do either right now, but I know that I would like to have more discussion about this. And I hate to turn everything into a working group, but I think that there needs to be more information. I would like more specificity myself. And I know that both sides are hard. Going with less specificity gives us flexibility, gives charters flexibility, gives authorizers, but I also feel responsible for these issues. These are health and safety issues for students.
But we're not saying that. We're just giving everybody a heads up. These are things that right now we have already considered these things as we're looking at charters. So it's just, it hasn't been written so that they weren't aware. So when they come before us, all of us are looking at these things beforehand and then asking them the questions, and they're like, sometimes they're blindsided because they have no idea. So this kind of, that's why I think I like this the way it is, because I think it gives them the opportunity to see, okay, these are the things that maybe you will be asked about, that will be considered, and so it gives them kind of a heads up. And I think it gives the charter authorizers a heads up too.
And I guess I'm saying I want more than a heads up. I want more. If they're going to be held to these standards, then I think that
it doesn't say that they're going to be held to these standards. It says that we're going to consider, and that the authorizers will consider.
And I guess I would like to have more information to the public about what you will be held to. I think that's a fair notion of governance.
Okay, Angie.
I was just going to recommend that one thing you could do, because it sounds like that, we're here right now and you'd like us to be more here. This is I would see this as a step in the right direction of where you'd like to go. We could start here and then maybe get a working group to get more prescriptive if that's what the board would want. But it seems like if the board is going to consider these things, I think it does sound like that might be something we want to set as an expectation.
We already have so many working groups. I don't know that we need another working group as well. But Elisa?
I agree. So I can see both sides of this argument and how you have to handle it. But as far as feeling like we have to be prescriptive, I hate to get too prescriptive, because part of the beauty of why people are choosing charters is because they want to do something different. And when we get too prescriptive, it takes out the innovation side of it in some degree. But I can see the arguments for some of this. So I just wanted to follow up with Royce, if you would allow that, to ask if he had any ideas for how to fix that language that he had concerns with on the infrastructure, because I can recognize that it could be very subjective. So let's say you have someone in a local community that really just doesn't like a charter school concept, or maybe has personality conflicts. They could then use, if we have it too subjective, they could use that to try to create roadblocks for a charter from coming in. But then at the same time, I see the health and safety part, because it is frustrating to have a school being built and then all of a sudden they're ready to open and we're getting all these calls talking about how the road it's a safety issue. And so I can really see both sides of this, and I don't know that I have an answer.
Again, Royce Van Tassel, Association of Public Charter Schools, for the countless millions listening in online.
We're a popular room.
Others have used that joke before you, Royce.
I'm sure they have. Anytime, you go to the committee hearings, this happens. There aren't obvious ways to fix that. Quite honestly. It's part of the reason why some of the legislation that Senator Evan Vickers ran a couple of years ago on this topic emphasized the importance really of saying, let's communicate early, let's communicate often with the community, so that you've got these issues coming out. And in many ways, he was focused, or the issue was focused on transportation, but it was left somewhat vague there, precisely because identifying specifics there is a real challenge. I mean, we have had communities who, as you have described, have tried to chase charter schools away. That's why the legislature said we're going to make charter schools a permitted use in all zones, so that there isn't NIMBYism that goes on to prevent charter schools from building in this community or that community. But even though they are a permitted use, there is a very real intent on the part of all charter school developers, of which I'm aware, to say, let's work as collaborative partners with the community. We're going to be here, partners, neighbors, for a long time, and let's make these things work.
Royce, can I ask you a question? So tell me what your concern is that it would be on this list of things that might be considered, because right now it is being considered. I mean, and if we got calls from 20, 30 people who said that we're concerned about this, we would consider that. And I would think that the charters would need to know that that's something that we might consider if we got phone calls from people.
I think I just want to raise the notion, and it feels like you're very aware of this. I know certainly the authorizers are aware of this, that the flexibility here cuts both ways. It can be both good, and it can be harmful, and that's really all my point is.
Okay, Elisa.
I'd like to I don't know if emotion's appropriate or not, but I would like to see this come back next month with, can we just refer to the code there? reference what.
If you remember, we have been asked to add this in by the committee, the Administrative Rules Committee. So it's not like
So they
it's
don't
something
want-
that's
okay.
in code. They want us to add
Well,
it
but
in.
I'm talking about just on the transportation or infrastructure piece. If we match the verbiage
okay.
in the code, but I know that.
Or if you want to, we can postpone and come back to this at the end and let Angie look it up.
Yeah, we could do that.
Do you want to do that?
I kind of more support your motion to bring it back again and let some of us work with people that we work with, come up with some language that might be more specific, but not too prescriptive. I think maybe just a little time can give us a little more time to work on this, because I look at adequacy, and that doesn't really, and I look at our situation with APA last summer, last spring, maybe, and this doesn't help us. I look at this language and I say, would this have helped us know what was right or wrong in that APA situation? And to me, ability to meet, no, it's the above that. It's one where it talks about community infrastructure.
I think you're looking at this wholly differently than I have, but I've been on this committee doing charters for a long time.
And
so I'm telling you,
not on this committee.
So I'm telling you, what we usually do is we look at their financial, but it's the problem is, I think, because it's not written down, it's kind of random, just like it was today, right? I go and I look at it and I think, okay, these are the things that I have concerns out, so I'm going to toss those out to people, and then they might be totally blindsided by that because they had no idea that I was looking at that. This kind of gives them an idea of the things that we look at, so they can be prepared, and so that's the idea of this. This isn't something we're going to be using against them or anything. This is giving them a heads up on what we already do, but so that they can understand it, so that they can be prepared when they come before us, or the charter authorizer can be prepared also when they come before. Mark?
Thank you, Chair. Thank you, Chair. I think after hearing the discussion, my takeaway, and I appreciate everyone's point of view on this, but I think I put myself in a lot of people's shoes, including the charters. I think it's about managing expectations and having consistency. And so as you're working through this, you say, well, in the past we've always done this, or we've wanted to do this. I think those items that you're going to list, like financials and a few of those things, those are all things that are considerations.
Right.
And if we had that list, it's not they shall make a grade or anything like that, but that's what's happened in the past. And I think I'm hearing you say we want to inventory that. And I think if I was on the charter side, I'd say I want consistency. I would like to know what you expect of me before this consideration of. And is that where?
Yes,
absolutely. Is that exactly where you're going? And it's not like you shall meet some test to have this done. And I think that can get where.
But that's applied. That's applied sometimes. We're working with a small charter school that is struggling very hard to do all the right things, and these kinds of things are being used against the charter school without notice of the charter school.
Well, who would abuse it if it comes to us and we're going to make a decision to increase their enrollment or whatever it is, whatever it is that they're asking. Shame on us if we're the ones abusing. But we need to. But I think moving forward, whatever it is, we need to be consistent.
And you can't be consistent when the language is too broad. My feeling is.
Okay, well, we get to details and say, well, there's this financial piece and this other, and et cetera.
And that's exactly what I'm saying. I think it just
because it takes the emotional side of
the expectations are. I think sometimes they feel like they've been blindsided. Maybe you should have Jennifer come out and blindsided by some of the questions that we've asked because they weren't prepared, and this would give them the opportunity to.
And I just like to look
to
at
be
it
prepared.
And I just like to look at it for another. I don't know that I need to hear. And I think the problem is I'd like to look at it for another month and see if there is language that's more specific but not too specific. Rather than to pass something that I feel uncomfortable about, but clearly there are 3 votes without me. So,
Jennifer, would you?
So Jennifer Lambert, Executive Director for the State Charter School Board. We do appreciate having these considerations that do give us these expectations so that there is alignment, so we aren't blindsided, just as you said. And so we support the idea of being able to have a list so we can ask those questions, and also so that we can provide you the information. There's often been a lot of back and forth where sometimes I think you feel like we're not giving you the information that you want to see. This lets us know what you want to see so that there's just continuity.
Okay, thank you, Jennifer. Michelle, did you have something you want to say?
I was just going to ask if there was a definition or something for community infrastructure that we use for public school buildings. And then if there is, because I see this problem that came up with the one school about roads. I mean, we had that issue in St. George with the new high school that was being built. People all around that community came out. This was before I was on the board, otherwise I didn't know what to do about it before, but there wasn't a road set. They were concerned about the roads and everything, and it turned into a big issue, but it did get taken care of within the community. But it sounded like the same issue with what happened with the charter school. So I'm just wondering, like, is there something across the board, whether we're building a public or a charter school?
Go ahead, Angie.
So I don't know if we have a clear definition of what infrastructure means, but I did pull up the section of code that Royce was referring to earlier. It's right there. It's 53A 2108. And if Royce is listening, I did not draft it. It was actually drafted by our local entity's attorney. And I'm looking through here, and there is a lot of information that the school or school district, the charter school or school district, are required to provide as they purchase or start to look at constructing on the building. So we could request for the information here. One of the things is it does require, at the very end here, you can see a child access routing plan. You can see there's a review here for potential community impacts, lot size, building size, estimated student enrollment, proposals for ingress, egress. So we could actually refer to and include that information as, instead of just having this broad term of community infrastructure, we could actually
reference the statute. Is that what you're thinking? Okay.
I'd like to make a motion then that on that line, which
Can we wait for just a second? I think Dave Thomas has been waiting to say
go
something,
ahead,
so
yes,
let's
please,
let Dave, and then we'll take your motion.
No, in fact, Angie has really kind of taken my thunder, which is that we already go through this process in the initial application. So the language is, whether it's vague or not, we're already suffering with whatever the vagaries are with the original application. So it's not so vague as to not be workable, because we seem to have been able to work up to this point. The other piece is that there is a provision in the State Charter School Act which requires the authorizer to review all infrastructure or facilities agreements. And so this is a place where that should be a part of the analysis that has gone through with that, as to not only to the original facility but to any potential expansions. And so that's part of the review. And so this is an issue that should be considered by the State Charter School Board as the authorizer. And while not all charter schools are authorized by the State Charter School Board, the lion's share are, and the other ones that are not, they have a different reporting line, and that's either through higher education or through the district, which we look at to say, well, now you've got a responsible entity that's going to be responsible for how that's going to interact. But the real one that this board should oversee is that particular authorizer, since it seems to be the lion's share of where they come from. And there should be the State Charter School Board has the ability to go through those through that review if it undertakes that.
Thank you, Dave. Now back to Elisa.
Thank you, and I agree with your sentiments on we oversee the State Charter Board, not the other authorizers are reporting to different entities. So, I mean, we ultimately oversee the local districts also. It's a different relationship. So, So I would like to make a motion that Angie's writing out for me right now.
Okay. While you're doing that, can I ask Jennifer a question? And it can just answer it from there if you want. I don't have to, it doesn't turn into a big
Actually,
production.
I need her to come to a microphone.
I just wanted to know if you do review those local agreements, those the ones that Dave Thomas just read that the authorizers are supposed to review, because that didn't used to be the case. Is it, or do you review all of those local agreements?
We do review them, but we're not going. We review them after they've started this. So if they don't have a building yet, if they're still, if it's at this point where they're looking to get approval, they wouldn't have an agreement yet for us to review, if that makes sense.
So really, the horse is out of the barn before you review those agreements.
Well, we review it before they're signed.
But not before the building is going up.
Well, no. So if you're talking about expansion, generally speaking, that's taken care of.
Expansion, no. But
right.
like
If you're talking about
maybe.
a satellite, they probably, it would not necessarily be in their best interest to already have the land before they're approved to get a satellite. So they need to be approved that they're going to get a satellite, and they may be able to get the land that they really want, or they may have to go to their next best
and do you,
choice.
I guess, yeah.
And so you can't review something that hasn't been approved
So
yet.
so realistically, you review these things only after it's in process, is what you're saying.
Correct.
Okay, thanks.
Okay, Elisa? Or Angie, who's going to?
I'll let Angie explain it. And then
Okay.
if I don't, because, I may not like it exactly. I haven't seen it yet.
Okay. Okay.
So the motion could be, and after talking to AG Dave Thomas, he thought maybe it does still belong in both the expansion and the satellite sections. But what we would do is we would delete essentially line 168, and let me pull up the rule again. And we'd need to do this parallel in the satellite portion also. So right now I'm actually looking at the expansion language, but we would essentially mirror this exact same language later on line 221. And that would be to include a new subsection F that would come in between lines 168 and 169. So we would delete line 168 and then include a new subsection F that says, so this would be that including the charter, so we would say, sorry, I'm trying to get up to the top.
So F now says any student safety issues.
So that would become G.
Okay.
And we'd renumber. So the new F, so it would say, shall consider the following, new F, impact to local government entities, comma, including the information described in section 53A 20-108. And so then they would just provide that information that they are providing as part of this section 53A as part of that expansion. So I would do that. I would include that new subsection right between lines 168 and 169, as well as in between lines 221 and 222.
Okay. Is that your motion? Has all
Yes.
all restated.
Well,
if that's the
yes, I
motion
just
you
wanted to ask a clarifying question. With this, it would still be under the consideration language?
Yes. Mm-hmm.
Okay. Mm-hmm. I'm just going to say so moved, and then she has it written out. Does that work?
I actually have to state it.
Yeah.
So
I'm going to need to state it.
Yes, you state
it. So what we will do is delete, the motion is to delete 168 and then add a new F that says impact to local government entities, including the information described in section 53A 20-108, and then also add that to, is it 221?
Mm-hmm. Right after 221.
Right after 221 as well.
Yeah. Okay. And then also just clarify to delete line 221.
And delete line 221 and then add it there. Yep. Okay. So is everyone clear with what we're doing? Okay.
Yes.
Sybil, you're good. Okay. Michelle.
I think Jennifer had something technical to add regarding what Elisa had just clarifying.
Okay, so that's the motion. Is there any further discussion? Jennifer, did you have something?
Well, just back what we were talking about in the timeline, that there may be a case where the schools at that time when they're doing the application wouldn't necessarily have all that information. So you may want to change it to be like an assurance that they will do it or something along those lines.
And then how do we,
so that it's possible.
How do we come back and find?
I think it's just saying that we'll consider it. So if it's not there, we can't consider it, right?
Okay.
Yeah.
Okay. And I want to explain my no vote before I vote no, and then I don't have to do it afterwards. But I really would like to spend a little more time on this. I think this is has proven to be a really troubling area for the board, and I'm not comfortable with shall consider. Would be more comfortable, I think, with some stronger language that gives better notice to what the charter schools can expect. And I am a little troubled by this transition period. Because assurances don't usually get followed up upon. So I'm going to vote no. And it's only because, not because I don't, I like greater clarity. I think this is a really good responsive move to some concerns that have been raised, but I just would like some time to do it right instead of just doing it fast.
Is there any other discussion? So this would go on first reading, and then it would go to the board on second or second and final. Which would you prefer, Elisa?
This is a philosophical question that I've been struggling with because the intention of switching the things I feel like anyways, I would like to see it go the 2 months still.
Okay, so you want it on second reading?
Yeah, just second reading.
Second reading. Okay. All right. All in favor? Aye. Any opposed? Okay. That's 3-1. So it's Bolter, Ellis, Hanson in favor, and Lear opposed. All right. Thank you.
I can. Then I could, but I just would rather do that rather than push something ahead.
Okay, we are now to the board bylaws. Or do you guys need a break? You good? Okay, board bylaws. Ben Rasmussen is our man here. Thank you, Ben.
We don't have a quorum. Oh, yeah,
we have a quorum. Yeah.
I thought she left the room.
Yep.
So, Ben Rasmussen, Director of Law and Professional Practices. This is part of our ongoing review of the different sections of the bylaws to determine if the members have recommendations for changes or not. Based on requests last month, we skipped 10 and then we've moved to 11 this month to talk about the committees and their structure a little bit. And so we've provided, we added to the backup this morning a new draft with some suggested language regarding the structure of the executive committee, a little bit about the audit committee as well. If the Andy, do you want to pull that up?
Oh yes, sorry.
And then we can kind of. Do you want to go through what you're recommending there, Linda, or would you like me to go through that, or how would you like me to?
Yeah, this is actually a current practice with the executive committee. So
sorry, let me get there. Which section is
so
it
we've
again?
added
It's on page 15
practice.
and 16 is most of the changes are.
Sorry.
To see if that's the way we want it, because
I'm good.
Elisa
There we
did
go.
bring up that what was in the bylaws, what was not our current practice. And so
No, well, so there was two things. One, we have in the board policy the fact that it says that, I'm just trying to find the right line. Basically, it's the open public meeting thing, and it says, you shall have, if you have a quorum, then we shall do this. But in practice, we haven't necessarily been opening it up. And so,
so that's
so
why.
that was kind of the question, and
that's
also to define the scope of what the meeting is supposed to be. That's one of the things I'd like to see, so that there's not so much question from the rest of the board, or leave it open to the discretion of leadership to, not necessarily that it's in board policy, but that the current leadership shall define as part of their duties, so that the board understands under different leadership what it would be. I mean, those are just options.
Okay, so let me.
So
Let's start at the audit committee, because that's pretty
You wanna do
easy.
the audit
Where's
committee?
and then we can talk
The
executive.
audit committee is on the bottom of page 16.
And so let's
right
talk
there.
about executive after, because I think that will be the longer discussion, right? So the audit committee, when I read through here, I asked them to possibly make this change so we could think about that. Because I think the way it was written, it looked like when it was written this way that there was just a chair and one vice chair. And so they put leadership on the audit committee, and then there were just 2 people. And then now then there's 4 people, and then there's no room for anybody else on the audit committee. And so I talked to Mark because I thought, well, maybe there's a problem that all leadership needs to be on. And he didn't see a problem with this. So my suggestion is we say the board chair and at least 1 vice chair shall be members of the audit committee. And then that will open it up for other members, or if you want to go ahead and put all the leadership on there, you can, but it will open it up so more people can be on audit committee. So that's my suggestion for audit committee, just so you know. Are there any objections?
No, I think that's a really great idea. And I like the way that you worded it so that you still could have them all on there. I think that's a great idea.
Okay, and then Ben, do you want to go through the executive committee?
The recommendations I got as far as the public meetings issue anyway is the language that we've put in subparagraph 6. It's towards the middle of page 16. We've worded it so that basically only 7 people can be there. There's priority to certainly the members of the committee, invitees of the chair of the committee, then other board members may come, but if it gets over 7, the chair would have to excuse anyone over 7 because there wouldn't have been public notice to have a quorum present. So we've worded that with that priority in mind as a suggestion.
Michelle?
Could we perhaps reward it where because I don't want to exclude people, especially if they'd like to come, and it would be really easy to do a public notice if we said within, you need to make your intention of being at the meeting 24 hours or.
That's how it is currently. We have a provision in there that.
And we weren't following that. Instead, we were saying, no, you cannot come. We've already got X amount of people.
Right.
Currently, the bylaws say you have to give 4 days notice, so that Lorraine can get notice out in time.
So I'd rather keep that way and actually do that practice rather than telling people no. Because we've got 15 members, and if 10 want to go or 11, I do not feel comfortable saying no to them.
And see, I look at it a little bit differently as the chair. I think as a chair, it's very, very difficult to tell board members no. And so when you've got the executive committee, only the executive committee is participating. But what you do have is you have other board members at the back, and then something comes up in executive committee, and they're like this. And as the chair, it's really hard to say to board members, sorry, And so I think that's difficult. I don't know. Mark can certainly weigh in, and if he'd like to, or you can. But I think it takes a lot more time in the meeting than to go the other way. So it's just.
Are you interested in my comment or feedback?
Yeah, go ahead.
We've got to remember the purpose of the executive committee meeting. The purpose of the executive committee meeting is to put agendas together. And board leadership puts the agendas together, and there's input that comes from committee chairs. There's input that comes from USBE staff that are invited to be there. That is the purpose of this meeting, is prioritize and put committee agendas together, and also the board meeting. That's our primary purpose. Before I move off of that, you have a question? No. Oh, okay. So that's our primary purpose. And no decisions are made except what is being placed on the agenda. And that's our duty, responsibility, and that's how we move forward. If somebody wants to spectate on that, and that's where we're kind of going, let me in, and spectate. As soon as we get 8 or more members there, then we're subject to open meeting. Same thing happens when we're emailing and everything else. 8 or more, and we're a governing board and a governing body. We need to respect that, recognize that, moving forward. And if we're creating another open meeting we're not going to get through our original task, because it's going to be, okay, let's take care of all this other business while we're doing it. We're not going to get through the original mission and purpose. So I just want to go back to, that is the goal and objective of the meeting. Not to set policy, it's setting the agenda and a bunch of prep for a meeting.
Okay, thank you, Mark. Elisa.
Yes, and they're very long, and so it gets very cumbersome when there's a lot. But I think that I'd like to see somewhere written the purpose, because I think that's part of the problem is board members aren't certain that we're just sitting there setting agenda, and it would also help board leadership stay focused and making sure that we do not deviate and start becoming opinionated about a specific issue, because that's not the purpose of the meeting. And so I think the way Mark worded it was done well. And I know that we had talked about putting in there so that we didn't have to, there's a law about what qualifies as an open meeting, and I'm talking to Dave Thomas right here. That's why I'm kind of looking through you. But and so it's just something that maybe we could consider, where we don't have to necessarily say you cannot come, and it would also possibly help us keep focus as board leadership to make sure that we are only doing these tasks at hand. But maybe he could just present this idea to see.
I think this is one of those things, and we hold on just a second, Dave, but I think this is one of those things that is going to have board discussion, right? It's probably one of those things that we can certainly vet, but ultimately the board will have the discussion and make the decision. But yeah.
No, and you've stated it exactly right, and that is that under the Open Meetings Act, in fact, one of the things that's interesting is that if you notice the meeting as an open meeting with the idea that you may or may not have a quorum, it's kind of hard to notice it as an open meeting saying, well, you don't have a quorum, so now we're going to close it, because you've noticed it as an open meeting. And so I think that, kind of even the practice we've had up to this point is a little bit fungy. You're saying, well, is it or isn't it? Are we or are we not? And I think that your suggestion is to say, look, let's focus on what it is. We live in that world with, say, like when we go into executive session, we have to be very disciplined in doing exactly what we're saying we're going to do with the executive session, or we lose that. It's the same thing with the open meetings. If we do have in the definition of open meeting, if it's for administrative or operational, and I doing the research on this, but I do think that the establishment of an agenda, because you're not voting on it, you're not establishing any final decision, but what you're doing is putting it on, and because our bylaws also provide a different avenue to put something on the agenda, that the agenda is not completely dictated by, you could say, well, it becomes dictatorial. The leadership will now ramrod through the board only what it wants to have considered on the agenda. Well, that's not the case. You can always put on the agenda matters that are brought forward by two board members. So you have a different way of dealing with that. But what it does is it establishes in an administrative matter that this is how it's going to be handled, and that's where it goes forward. And if you stay disciplined within that, then you don't have to worry about the Open Meetings Act, because that's not what the Open Meetings Act is about. The open meeting is to be transparent as far as the decisions that are made by that governed board.
So you could have as many come if we set, okay, I like that idea.
The whole board there, because
I like
it's
that.
not considered to be a meeting.
Right.
Governed by the open.
Because we're not having a discussion, we're just listening. They are having a discussion.
But it would help limit it.
Right.
So one thing that
And again, that's the very point. It focuses the discussion. You'll have a wide-ranging discussion as to whether that matter should be brought before the board or not, and and all of the different ramifications as to whether it should be put on the agenda. But it's always focused on whether it's on the agenda, not whether or not it's a good idea, not whether or not it should be voted on, not whether or not it should be transparent.
Okay.
Yes.
Elisa, did you have?
I did. Anyway, so I'd like to see some language that would show that also.
Okay.
And then I think we could wait a month to take it to the board.
Well,
because people get annoyed when we bring them a couple different ideas.
I think we need to make sure we have it clear here before we go to the board. Is there anything we want to take to the board, though? Because I'm thinking if we want to decide
Well, it would be
audit
good
committee,
before the beginning of the year.
it would be good to do that audit committee change before the
What
beginning
we
of the
have
year.
been doing is just kind of accumulating these so that we can take groups together rather than take every section to the board at a time.
Right, but
Are you suggesting you want to
But
handle this differently?
they're going to have to decide who's going to be on the audit committee, and if we're going to change how they do that, we probably need to do that in January, so they can.
Understood.
So that flexibility will be there for them. So. Yeah, go ahead.
So is maybe the direction that we prepare some language that describe a purpose? And then I guess the question is, do we want to eliminate this language here that says, is that what
Yeah,
we're hearing?
let's talk about the language that's in here and see if we could agree on this, because we know we want to put the purpose
Are you
in.
referring to
So
exit?
No, we
sorry.
talked to the audit committee part
So
already.
now
Let's go
executive.
back to page 15.
So there's a couple.
Where the red part is.
There's a couple of principal changes, and there's one we haven't mentioned yet, is that we put in the suggestion that the chair may invite the committee chairs to be actual members of the executive committee, which wasn't in there before.
Okay.
So we've added language to that effect, as well as to the paragraph as to who can attend the meeting.
So as you see that, number one, is that number two or is two? Two's just, okay. Do you have any concerns with that language? The board executive committee shall include A, the chair, B, the vice chairs, C, the chairs of the standing committees if invited by the chair, and D, the superintendent. Is there any concerns with any of that?
Where's the language about who can attend?
It's down page 16.
We'll get there. We're gonna, okay, so just that part, are there concerns
Right. No,
about that,
I just had
Elisa?
a question. So, moving around. So I'm just trying to remember, and you guys may know this off the top of your head. So the chair's duties include this to do this. I'm just wondering between chair and putting chair and board leadership, or do you know what I mean right there? But I think that's already defined as the chair's responsibilities elsewhere, correct? That committee meeting?
I don't know what you're talking about.
So sorry. So you're saying that you're putting the sole responsibility on the chair's head on whether or not instead of board leadership.
The chair.
I'm not sure if it does, though. That's what I'm trying. I just want it to be consistent.
It does talk about, I think the chair invites. Yeah. Is that what you're talking about?
Yes. I'm just trying to be consistent.
Yeah. I think it says the chair invites.
Can I throw in on this?
Yeah. Go ahead, Mark.
I did a little research on that to know duties and responsibilities. A lot of times when the reason it says chair, because you can vote the chair right out in that, but if you say leadership, and back in the day it was only two, and so how do you define what leadership decided? Mm-hmm. Then you have a meeting, you almost go into motions. What happened? How did you inventory? What was the vote? How? And it complicates a lot.
Okay.
And so that's why it says, there's a lot of things that says, well, just one person's going to make the decision, and hopefully that person gets input from other people, but you don't have to document the process of the discussion of how that happened.
You're right, Lisa. I forgot about that part. So it says, it does say
meetings, more
if invited by the chair or board leadership.
I don't necessarily agree that it means more meetings, because it can be phone calls and such. I think it's more of a protection for a chair to have a wider range of input so that they don't get accused of being dictator.
So we probably need to change C. So it says if invited by the chair or board leadership. So it matches.
Well, then it's kind of at the discretion of how the chair wants to operate too. If you have the or language, because they could still make the decision by themselves if they chose to. But
yeah,
this is a little bit two different issues. Isn't this who gets paid for attending the committee?
Yes.
Who is actually a member of the committee?
No, I thought we were asking who, if it was defined elsewhere.
They are different, a little different, but
what Angie's posted up here, I think, is who gets, or had posted up there as far as the board policy. is who gets paid for attending the committee.
Right.
That's what
If invited by the chair. So I couldn't just say, hey, I want to go and then sit in the back and get paid. I'd have to be invited by the chair to come and give input. So
I don't think it really matters. I'm not going to quibble over it too much because in practice, we've had discussions as leadership. It hasn't been a sole decision. So,
okay.
But if we wanted to be consistent.
Okay. And the superintendent. So, and then we go down to 2. The deputy superintendent shall serve as staff to the committee, and that's a change, right?
No, it's just
the same. It's just moved.
Just restructured.
Okay. All right. So are there any concerns or objections to that part, Elisa? No. Okay, and then we're down at 6. Members of the board who are not members of the executive committee may attend the committee's meetings so long as no more than 7 board members are present. Invitees of the chair shall receive priority for attendance. Any remaining slots for attendance will be filled on a first-come, first-served basis. Non-committee members may attend, but should not expect to participate in committee business. Elisa.
I would like to just see this portion withheld until we saw another version. So, because you were wanting to move forward with the audit part. Anyways, that's just my own personal preference because I'd like to see the.
So just this part right here, or do you want?
Well, I think the other part's all fine, even if we were to change that.
The executive committee.
I would like to see a definition of what the purpose and scope of the meeting is written out.
Yeah, and I'd like to see Dave Thomas's idea kind of written out.
So just, are you clear there, Ben, on what they want included and what they don't? And so
you
take out 6.
Strike that paragraph, and Dave's going to come back with some new language.
Yes, but if you wanted to move forward,
we can provide to the board next.
So that the board can vote on them and move ahead. And so, do you want to make that motion, Elisa, so we can?
I move that we move forward section. Does anyone know the 11 on audit committee? Oh, sorry. Are you now at?
I would actually just make the motion for the bylaws because there is the one change from last month.
Okay.
Oh, that's right.
I would like to make a motion that we put the bylaws as amended forward to the full board for approval, except for section 6 under board executive committee, 5 and 6.
The changes to 5 and 6
on board executive.
So the motion is that we put forward the bylaws for approval as amended for approval to the board, except for sections 5 and 6, the amendments to sections 5 and 6. Is that right? You clear? Okay, are there any concerns or discussion to that? Okay, all in favor? Aye. Any opposed? Okay, that's unanimous.
I didn't vote, Sybil, because I didn't hear the discussion. So.
Okay, so it's 3 ayes. All right. Thank you. We'll work on that section and right. Okay. Thank you. Thanks, Ben. Do you have the next one too, or we? Yeah. Okay. R277515 Utah Educator Professional Standards.
So we've made a number of changes to this to continue the rule at the board meeting. The main board meeting last month, you may remember that board member Brittany Cummins raised a concern about one particular paragraph, and it was recommended that this be referred back to the committee to discuss the rule a little bit. The specific provision, as I recall, that she had concern with was on lines 249 and 250. It says that an educator shall take action to protect a student from any known condition detrimental to that student's physical health, mental health, safety, or learning. I think board member Cummins felt that was a little bit broad, so I guess we would throw it out there. I think where the language, where it restricts it to a known condition of the educator's aware of a known condition, I think I'm comfortable with the language from my standpoint, but obviously I'll throw that out there, see what you have to say.
Okay, board members, do you have any concerns or on anything else in this rule? Because they did throw it back to us to take a look at it again to see if there were anything else, if there was anything else we wanted to change.
I'd love to change a lot of things in this rule, but I didn't know that it would be up for discussion in every item today. So my druthers would be to revamp the rule in many different ways, but I can't really today because I didn't think the whole rule was, other changes were going to be received. But so I'll just probably put some together and in a couple months maybe bring it to the.
Okay, so then we have, does anybody?
Leave it thinking that I'm okay with the rule because I'm not, I think.
So are there concerns about 249 and 250? As I read it, it seemed broad, but then when I read that from any known condition, it would have to be something that was known detrimental to the student's physical health, mental health, safety, or learning. Do you have concerns about that? Do you guys want to consider amendments, or are you okay with it the way it is?
You've got the provision that just changed in the legislature last year about how you can interact with students, how educators can interact with students. If it's having to do with property damage, and I'm not sure if this would even be a conflicting or be a compatible provision with that. Maybe it ought to be consistent at least with that section. And if there's no relevance, then can you look at that, Angie? I don't remember there being anything that would probably.
I mean, right here, just right above, shall resolve a disciplinary problem according to law, LEA policy, and local building procedures. So you could, I don't know that the physical restraint or the touchings, those may or may not be disciplinary issues, but there it would essentially, if an educator weren't following the law about that physical,
would trump the one below. Is that what you're thinking?
Well, actually, they're both. I would just say they kind of. There's a couple places, but they're broad enough that I think that the law, as stated, and then any changes we made in 609 or other would apply to those educators. So if they weren't following the law and the rules and policies of statute, I mean, that could be something. So
do we even need 249 and 250? Is that handled in other statute and other?
Well, I mean, it is handled in the sense of directing how they should handle it. The question is, if they don't do it that way, are you asking Board Member Lear if that means that then they could have a UPAC case brought against them if they don't?
It might be a conflicting message to educators, which, again, I feel differently about these rules. I feel like we should give, the board should be bound by these rules, and we should give fair notice to people about them. So I'm saying that I'm not sure if the message is clear enough, but it might just be my responsibility to sort of come up with some language that I feel is clearer if I don't like it. So I don't have anything in the moment that would make it better.
Okay. Anything? Yes.
Sorry, I just wanted to clarify. So if we were to keep in lines 249 and 250, is it defined somewhere how we determine what a known condition is? Is that what you were saying, that it's defined in other parts of statute?
There's no definition for that, no.
And known by whom?
Yeah, well, that's what I'm wondering. It's so subjective, and that could cause a lot.
And maybe that's, we need to be a little more specific there on what kind of.
I just don't know how you'd even clarify that to be more than known. It'd be very fact-based.
Do we have to have it in there?
I think you could change it to a condition known to the educator to be detrimental. I mean, I think what it's trying to say is that if the educator's on notice, they need to.
Yeah, and I guess it would have to be something that was like written, or, I mean, you know what I mean? Something on a 504 or IEP certainly would be known to the educator, but otherwise, how would you know what was known to the educator and that was not?
What if we has to show?
Yeah. There's somebody in the back of the room.
Michelle, I'm sorry.
Oh, sorry.
Michelle,
no, I was just wondering if maybe we could put in there like, shall take action to protect the student from any known condition, and add in like parental, like where they got parental knowledge. Is that what? Because that would be the only way that they would know of a condition is if a parent came in and said.
Not necessarily.
Could come from an administrator.
It could come from an
It could come from
administrator, like the
administrator.
IEP could include something that's
Their
passed on to
records.
them.
If-
their
Just
records.
their
If we don't have anything specific that we want to do right now, then I think we should just go ahead and I'm going to move on to the next item. And then we can, if we want to bring this back at some other time, we can bring it back at another time with some other changes. But since we don't have anything specific right now, I think we'll just move on.
Linda, I'd like to hear from the person at the back of the room that
I'm sorry, that's not your prerogative.
I'm just saying I'd like to.
We will be moving on to R277415, Standards and Procedures for School Nurses. We are running out of time. But we have licensing left to do.
Scott's not here, so you can use his chair.
Hi, I'm Betty Sue Hinkson, State School Nurse Consultant with the Department of Health and the Board of Education. So we have two items today, and Ben, do you want to talk about the first one?
So the first one on the agenda is R277415.
No, it's against the rules. It's
So
we'll be taking a break. Thank you. We'll take a 5-minute break.
okay.
I lost my quorum. They'll be back. Sorry. You know, it never was this difficult when I was just a member. We now have a quorum, and we will go back to R277415, Standards and Procedures for School Nurses. And I know that there are board members with questions on this one. So let's go ahead and it's Ben, right?
Yes.
Ben's going to go through it for us. Start us off.
Just want to point out to start out with that we have done a revision one here based on some feedback that we got on the original proposal we got on this rule. As you may recall, Betty Sue Hinkson came before the committee a couple months back, and we talked about the need to have a rule that outlines how the board will make determinations on matching funds, and so that's what we have before you. We have deleted some language on lines 18 through 24 and also lines 35 through 41 over concerns over what was delineated as possible responsibilities for LPNs. You've got three.
We've got 1, 2, 3. Carol. Oh, Carol's here. Sorry. I'm keeping track.
So we have deleted that language there, and then we've also changed the language regarding the term matching funds. Assistant Superintendent Grange asked us to use some different terminology there for finance purposes, okay. And so we've changed that throughout the rule as well. And so I think if you have questions, I think they're here to answer those at this point.
Okay, I think that will probably resolve a lot of the concerns that people had. I know Michelle had some, Lisa had some. Do you guys still have things you'd like to talk about?
Yeah, I got a text from someone that had been concerned with this, and it was on lines 59. I'll just read you the comment. The problem that they see is 59 to 60, where it requires students to provide a physician or advanced practice registered nurse consultant, and they're trying to figure out, they feel like it goes beyond the law that authorized the rule, and they couldn't find anywhere that there was a requirement. The matching funds, I know that was a concern, but that's required by the law, correct? Yes.
In order for a school to meet other laws, for example, the epinephrine law, there has to be a physician or a prescriber that will be able to prescribe medications. Occasionally also, nurses will have standing orders or schools will have standing orders for over-the-counter medications, Tylenol and ibuprofen, and that requires a physician's order or an advanced practice registered nurse. And so it is common practice for there to be an oversight of a physician or a advanced practice registered nurse connected with each school. It doesn't always happen, and that makes it very difficult for school nurses.
Okay, so a district would have someone that's appointed for the entire district, or just is that how it usually works?
Typically, it would be for each district. Our charter schools do that individually. It's usually done with an MOU. It can be on a voluntary basis, or it can be specified in the MOU if there's financial compensation for that arrangement.
When you say prescribe, are they writing prescriptions?
For the school, not for individual students. So
for the school to have?
Yes. So we have an epinephrine law that states that every school must have an epinephrine device. But in order to get that, it's a prescription medication. You need a prescription written for it. So not for individual students in any way. It's for a general school population.
And I'm not sure if this is your language. I'm not sure if this is your language or Angie's, but oversight. What is meant by oversight?
Whenever a nurse has questions on medical concerns, they might need to contact a physician. For example, let me think. Probably specifically those two areas that we talked about, the epinephrine and the ibuprofen and the Tylenol. We would need specific dosages for different students. If we have a standing order at schools for example, Tylenol, not everybody gets the same dose. It would be based on age and weight.
And given that there are sort of sometimes big areas that these school nurses cover, is that a realistic, is there realistically someone that the school nurse could contact?
Yes.
Okay.
Yes.
Okay, because I don't want to put something in rule that is impossible to have.
No, it's common practice.
This is your current practice.
This is our current practice.
Okay.
Yes.
Okay. That's helpful. Thanks.
Are there other questions? Elisa, Michelle?
No, I'm just wondering. So this, I think part of the concern is that it was going to be for individual students. I think because these concerns were raised by people outside of the, just in the general public.
No, never for a specific student.
And so I'm just wondering if that's reflected somewhere else in the rule, or if
I don't believe it is, but
if we could just clarify so that as the public looks at it, they aren't concerned that the schools are going to start writing prescriptions for their children without their consent. That maybe we could just make an amendment that clarifies that it is prescriptions for the school to have based on law and not for individual students.
We haven't got any language right now about specifically that the physician would be providing prescriptions. Do you want to add some subparagraphs there that specifically talk about that ability?
Well,
and that's just kind of raising a new issue.
I think what the problem is when I read this, I read it as for children, that they would be doing this for children. And so if there's at the beginning or something clarifying that this is for schools, not for individual children, that would put a lot of concerns that parents have at ease.
So somewhere to highlight, because looking on line 60, it does say to the LEA's school nurse program, not an individual student.
I know, but I still read it that way, that it was an individual student.
Right. So I guess I'm asking for help in how we might be able to highlight that a little bit more.
I don't know, maybe at the beginning of the rule or something say, I don't know how Angie, this is where I turn to Angie and ask her, how would we clarify that this is not for students but for schools?
Could we put some language in the paragraph 2 of the authority and purpose that just clarifies that the rule does not...
Yeah, maybe the purpose?
Yeah, that's a good idea. I like that idea. Ben, do you want to try and come up with something right now? The reason why I'm pointing to Ben is because Ben's been the primary drafter of this, so...
I'm trying to think of what the wording would be, but I can work on that.
Do you want us to postpone and come back to it? We can.
Yeah. And we can even work on it after next month, too.
We have the APT report, and we can work on that while you're working on that.
And talk about that.
And then come back.
Do we want to revisit it today, or?
We can revisit it today. If you're ready, if you're quick. Okay. Okay, that would be great. All right. Thank you. Okay, we'll go to the Academic Pathway to Teaching Summary Report. Yeah. So.
Oh, there was a second.
There was a second issue we wanted to talk about. Do you want to do that now?
Okay.
Yes.
All right. Sorry.
Okay, so I mentioned this the last time a couple of months ago when I came before you that the Department of Health had recognized that there was a place in the statute that says that something along the lines of students or schools, LEAs that are less than 5,000 students needed to staff their schools with nurses according to recommendations by the Department of Health. This had never been written. And so I put together a staffing statement that addresses not only LEAs with less than 5,000 students, but for all of them based on...
Can I just interrupt here because I'm a little confused. So are you just bringing this to us for information only? This doesn't look like something that the board would necessarily approve.
That could be correct. I'm not sure. It's a Department of Health document that they'll be putting out, but because it does impact schools and it relates to schools, they wanted you to be aware of it.
Okay, so you're here to give us the information.
Yes.
Okay, thank you.
So this is the statement that's been prepared, or the staffing recommendation that's been prepared that was given to you. Instead, in the past, school nurse ratios were often based on numbers of students only, students enrolled. So one nurse for every 750 was the national recommendation. The statute in Utah says one nurse for every 5,000 students, which is quite different from 750. But that doesn't tell you the whole picture. So that only looks at numbers of students. It doesn't look at students' health issues, their health disparities, their social disparities, any of those things. And so we've developed this statement so that as schools look to staff with school nurses, they have some guidance in how to do that based on all these different areas, the acuity of the schools. We did send this out to our student services directors to get comments from them, and we got some really good feedback from them saying that this is really a great idea to have some guidance on it. However, they wish there was more funding attached to it so that they could actually meet these recommendations.
Can I ask you a question about that?
Yes.
Does it concern you as working with the nurses that having these recommendations in writing and that it's not going to be part of the board rule, but does it concern you at all that it puts, maybe it wouldn't concern you that the schools are, I feel like when there's such a huge disparity from the recommended size to the actual size that it might cause some concerns for the nurses who actually have to do the work.
They already know that there's a big disparity between the recommendation and what's happening in Utah. They oftentimes just wanted something in writing that would say this is what is the gold standard, I guess, of what would be the best. This is not going to be required. It's just in the best possible world. And this was very difficult to come up with because we do have some districts, one district that has a nurse in every school, but that's not common in Utah. So to write a statement that would not that would be appropriate for their district, and then for our smaller districts who might have a 0.25 employee for their whole district, trying to fit the needs of everybody. And so that's why the statement at the end was written so that some schools would have one full-time registered nurse, which is the national recommendation that each school have one full-time registered nurse. That's not realistic, we understand, in every school. So these are the recommendations that we would make. So either one full-time registered nurse per school or several full-time registered nurses per school, and then in particular this would be your special ed schools where they often will need 2 or 3 or 4 even nurses to care for the needs, those special health care needs that those students would have. Or one full-time registered nurse for no more than 5 schools. That would allow the nurse to visit each school 1 day per week. In the absence of the nurse, they are often delegating procedures, and part of the delegation process is they need to supervise and evaluate those lay staff people that are doing the medical care for our students. And then with districts with less than 5,000 students, they should try to meet the above requirements, but if they can't, there's a chart below. And that chart is based on the low number is the 1 per 750 that's recommended by Healthy People 2020. The higher end of the chart is the 1 per 5,000 that is in current Utah statute.
Thanks. Okay. Are there any other questions on this information? Tina, did you have anything that you wanted to?
No, not at this time.
Okay. Let's see, Elizabeth. Do we have Elizabeth here? You are Elizabeth.
I'm Elizabeth.
Okay.
Betty Sue Elizabeth.
Sorry. You're signed up here for public comment. So. Okay. So let's go ahead and review the language if that's all right.
Yeah, I'm just going to unpause this. So Ben, Dave, and I just quickly commiserated. I don't know what the right word is.
Collaborated.
Collaborated is the better word. But maybe to add at the very end of the rule, a new subsection 14 that just states that nothing in this rule gives any medical provider authorization to prescribe medications to a student without the consent of the student's parent or guardian. Is that good?
Maybe except in an emergency situation. I mean, even if there's an emergency.
Just prescribe, though.
Prescribed. That would be true.
Not administer.
Okay.
Other statutes already give the authorization in an emergency.
Okay.
Yeah,
So
and they
does
would
somebody
trump.
want to, you know what, I'll just make that motion. I make
Okay.
the motion that we add that to, can you want to add? Okay.
Sorry.
So we're adding to R277415 revision 1, number 14. Nothing in this rule gives any medical provider authorization to prescribe medications
Sorry. Just trying
to a student without the consent of the student's parent or guardian. Okay. So that is the motion. Is there any discussion? Okay. All in favor?
Aye.
Oh.
I was just going to say thank you.
Oh. Aye. Okay. So that's unanimous.
Yep.
So now we have the amended rule before us. Are there any other concerns or questions about this rule?
Whitney is suggesting that we change that to the written consent of the student's parent or guardian.
Okay.
Oh, without the written consent?
Are there any objections to that change? Okay. Civics got that. Okay. All right. Thank you. Thank you, Whitney. All right. So the amended rule is now before us. Do you, is there any other discussion? I could use a motion. Elisa?
Before you move, I just wanted to make sure. Betty Sue, does this have everything in it the way you'd like to see it from the nurse perspective?
Yes.
Student to school nurse perspective.
Yes.
Thanks. That's important to me.
Thank you.
Elisa?
I move that we approve R277415 revision 1 as amended to the full board.
First reading?
First reading.
So it'll be read for the first time, and then do you want the board to approve it on second and final?
No, I'd like it a second.
Okay. So the motion is that we approve R277415 on first reading and recommend that the board approve R277415 on second reading. Yes, as amended. Sorry. Elisa?
I just wanted to, Angie or anyone, we're not on a time constraint on this one, right?
No.
Because for me, I don't want to be in a hurry.
I was going to ask the same question. Thank you.
Betty Sue or Brian, are we?
The application opens in April. I'd like to have it in place by then.
So that means
It'll be all
It would be in place by April because we voted on in February, early February, published February 15th.
Do we need to
End
do
of March,
second
it would be effective.
and final?
So yeah, like April 8th, it would be effective. Would that be early enough? If it's
We can do
legally
second and
effective?
final. That's
It used to be the application was only open for a week. I opened it up for a month. I didn't think a week was long enough. But we can wait until after April 8th and then extend it into May, I think.
If you want, whatever you want to do. I don't want to make it more difficult on them either. So.
I'm fine. Let's do second and final so that it gives the public time after it's in place to know exactly what they need to do for this application process. That's fine.
Okay. So the motion is that we approve R277415 on first reading and recommend that the board approve R277415 on second and final reading, as amended, on second and final reading. Any other discussion? Okay, all in favor? Aye. Any opposed? Okay. Thank you. Thank you very much. Thanks for your patience. Yes, Lillian.
Thank you, Chair Hansman. I just wanted to recognize Rebecca Fronberg from the Department of Health. She's here with us today. Our collaboration and partnership that actually shares Betty Sue. And so I just want to acknowledge her and the work that she does in this collaboration effort.
Rebecca, what's your position with the Department of Health?
I'm program manager for the Healthy Living Through Environment Policy and Improved Clinical Care
It is a very long name. Thank you for coming. Thanks for being here. Okay. Now, let's see. We are on the Academic Pathway to Teaching Summary Report, Travis. And I think, Diana, are you coming up to? You'll wait for the next one? Okay. When we passed APT back a year or so ago, we said that law and licensing would occasionally get the report to see how things were going with APT. That's one thing we promised the public, and so I asked Travis to come here with a report on how things are going. So we'll turn it over to Travis.
Thank you. My name is Travis Rawlings. I'm the Educator Licensing Coordinator for the State Board of Education. The report was put together essentially as statistics to help give you reference. It starts with having just a general feel for how teachers are licensed. You can see that APT at the end of last year was less than 1% of teachers. That's pretty consistent with what we had anticipated. Overall, you can see that they started out in the 20s and 30s back in September, but they did end up with about 314 such licenses issued by the end of the school year. Probably most intriguing to me was not necessarily the number of licenses issued, but the license areas and endorsements that people were requesting. It was not as we had anticipated. We kind of suspected there might be some of the more high critical needs areas where this might be coming up. But ultimately, it turns out, math was the second highest, but the highest was English. So I don't know what that means. That's, just data I can present to you guys.
Could that be English language learner type things, or is that English?
That would be English language arts.
English language arts, yep. Okay.
And ultimately, you can compare that to the data below where it talks about not just the licenses issued, but the licenses where people were actually hired. And yes, 27 of those 44 English licenses were hired. So I have no idea what that means.
Travis, one second back. Sorry. As I manipulate Michelle's computer. You have 314 in 16-17, and then 187 17-18.
Yep.
Do the 16-17 licenses keep going? Do they endure? There's no annual requirement?
They can't. They're a 3-year license.
Oh,
and so they would be included. Now, if you'll notice, they don't add up.
Yeah. Yeah.
That might be confusing as to why they add up. And the reason for that is because some of the individuals have subsequently surrendered their license or decided not to do, they dropped the APT and decided to do ARL, or they did WGU or whatever.
Okay.
So that's why it doesn't add up.
Thank you.
I know that bugs me as a math teacher too.
No, that doesn't bug
I
me at
triple
all.
checked it.
As an English teacher, it bugs me not at all.
There you go. Ultimately, as you can see, many districts and charters are utilizing this situation, these types of licenses. It's not restricted just to charters, which was one of the things that was suggested. There certainly are districts that have chosen not to pursue this or to have very limited involvement with it. I mean, if you look at Alpine School District having one APT license, that's, considering the size of Alpine, that's, them really saying we don't really do this. But at the same time, you've got
but they used it as an option when they needed to.
Yes, they did. Absolutely. They used it as an option when they needed to. So the other thing I did not put in the report that I found interesting is the various ways that LEAs have found and have decided to try to help train these teachers. You've got a grant that was used for Tooele School District, Weber School District, to work with Weber State University to take actual, postgraduate classes through Weber State at no cost. There have been a number of rural districts that have gotten together with their regional service center and created, courses and classes that they want people to do to prepare them. There's been a charter school consortium that did the same thing. There have been various vendors that have, certain districts and charters have said, yes, this is what we'd like you to do. And so it's hard to summarize all that because we don't track it, but it's been a very interesting hearsay conversation, if nothing else, when districts and charters talk to me about what they're doing.
Travis, can I ask you a question about that grant? Because I have Tooele School District, and I thought they were using it only for ARLs, but they're using it for APT as well.
I cannot speak to Tooele specifically.
It's the same grant that they had for.
But I know that grant is being used for both.
Okay, interesting.
Yeah.
Okay.
Other than that, that concludes our report. Unless you have additional questions on this matter.
I found it very interesting that some of my, some of the rural districts I have are not using it as some of the urban ones that complained that they didn't want it. So I found it a fascinating report. So I really appreciate you sharing this with us.
Would you have any way to track this going forward? Would you have any way to track this going forward so you'd know, meaning how many started at APT and then how many did we lose the next year and how many?
Absolutely.
I'm just curious if it's going to be enduring.
We certainly can. We can easily identify them. That's how we pulled all this data. It's hard to make comparisons because you'll notice there's one note that says we have 1 year of data. So of our data, we retained 93.5% of those teachers. Is that good or bad? Well, we don't know because that N size is so small compared to our overall teacher N size that it's hard to compare. But, we'll continue to have this data as we feel we need it.
That'd be helpful.
Yeah.
Travis, do you feel like they're using APT instead of maybe other LEA licenses they were using in the past? Or
we still have a few LEA-specific licenses which are most similar to an APT in very unique situations. But the use of those licenses has decreased, just from my own, how many I've seen come across my desk, if you will. But I was looking at the ARL data earlier today, and ARL's about the same as it was the previous year. So this may just be speaking to the overall need for teachers, quite frankly.
Okay. All right. Board members, do you have any questions? No? Okay. All right. Thanks, Travis. I appreciate that.
No problem.
Now we are to the licensing issue here. Educator licensing revisions. We are going to be looking at this for several months. What we're going to do here today is, I understand these guys have some questions for us before they actually start writing the rule. So we'll go to those, and then with whatever time we have left, I have 4 people who have signed up to give input, but we'll do that at the end as we see how much time we have left, since we have to finish it at noon. Okay. I'll turn it over to you guys.
Go ahead.
So I was just going to introduce it because Travis is really the one who's doing all the heavy lifting on this. So we took what we presented to you last month, and where we didn't get specific information about do it this way or that way, we just went with what we thought was best. And that's what you see before you now. So you have an outline of what we think would be the components of a rule. And what we would really like from you today is anything where you disagree or where you would want to talk about some. Travis is going to point out a couple that we think really you need to think about before we turn them into a rule, in the hopes that when we come to you with a rule, we won't have to keep going over it and over it and over it, that we'll have what you intend right from the very beginning.
Okay, thank you, Travis.
And Chair, just to clarify, would you prefer that I do one question at a time and then have the discussion, or would you like me to go through the questions themselves?
I would actually like you to kind of go through the outline for us a little bit.
Oh, okay.
So that we kind of make sure that we're all on the same page before we start with the questions,
Sure.
if that's okay.
That is perfectly fine.
Okay.
So the document that you have before you, normally when we prepare a rule, this is actually, when I prepare a rule, this is what I start with. We normally don't share this with the board, but ultimately this is such a high stakes issue. I was going through this, and this is probably where we need to start with this one. So it starts with, I'm kind of skimming over the authority and purpose. The program approval and requirements. This is an aspect of the rule that applies to university preparation programs, and it's been something that the board has talked about in the past. And ultimately, the decisions based on this about replacing the program entrance requirements was about the board deciding to drop CAPE accreditation as a requirement. If you remember back in August, it's kind of along those lines. The third bullet there is probably the most important one when you think of this aspect of the rule, because it is really setting the deadline of when a person's getting into a teacher preparation program, when are they held to the new standard or when are they held to the previous standard. So that date on that third bullet is very, very important. Okay. The next section, section 4, is talking about the general, it establishes the licenses themselves, the relationships, having a license area, and an endorsement. The important aspects of this are, the length of the associate license. That's been something that you've received a lot of feedback on how long should the associate license be allowed to be used. And then ultimately the LEA-specific license here, this is the meat of what it means to have an LEA-specific license. This, how long it's for, that it has to be in a board meeting. One bullet there that you may or may not want to do is that the first renewal of such a license requires the state board's approval. There's some people have liked that, some people have not. So again, it's just an important decision point for you.
I'm sorry, can I interrupt you just to ask Angie, can you make that any bigger? Yeah. Just a little control plus. Thank you. That's great. That's perfect. Thank you.
And then, so from there, it goes into the section talking about license areas. And so this is where we distinguish between the different types of licenses that exist, such as elementary, secondary, administration, speech-language pathology, all the different types of licenses. One of the things that's very important in this one is, first, that we are proposing that we stop licensing school social workers and audiologists through the board, because they are duplicate licenses with the Division of Occupational and Professional Licensing. And some of the statutory things are dealing with some of the funding issues with that, but that is one of the big issues there, is that we're saying they'll be licensed through DOPL. We don't need a second layer on that. Subsequently, also, it talks about defining what a micro-credential is. And this has always been the difficulty the last year is what does a micro-credential even mean? And so what we've kind of established here is that the superintendent can create micro-credentials, and what they are is they're either, narrowly defined is usually the word used, but it's either targeted towards a micro-credential for a specific course or a very specific skill or knowledge. And so this distinguishes between an endorsement, which is a series or a set of competencies, versus a micro-credential being a single, set of a single competency, if you will. So that's the distinction there. And the next sections, the next one, returning educator, I don't think we need to talk about that. But from there is where it really gets into the requirements of the various licenses. And so the way it was structured, or that we're intending to structure the rule, is that every license has 3 kinds of requirements: general requirements, content requirements, and pedagogical requirements. So if you look at the associate license, you'll notice that the bulk of the requirements, the most hefty requirements, if you will, are surrounding general and content. The pedagogical requirements are very, very minimal. Ultimately, it is 1 or 2 micro-credentials or that you're in a program. One of the things I should note on this, though, under the content knowledge, you'll notice under special education, it simply says enrollment in a board-approved teacher preparation program. What we're saying is that for special ed, there's no shortcut. There's no way around it. You must be in an established program, period. And just because of the feedback we've received, we thought that was a very important thing to do.
Just clarify what you're saying, Ben, Travis, that ARL people, special ed can't be ARL?
So, well, ARL doesn't exist.
Right.
But, so the intent is that special education preparation needs to be through an approved program. And right now, the only such approved programs are either university programs, be it traditional or alternative. We do have alternative special ed programs in our universities, but this would remove that from, say, an ARL or an APT. That you don't do special ed.
Okay, unless you're prepared traditionally, is what you're
or
we're
more
saying.
traditional.
What you're saying.
It's a.
And I get the university programs that are alternative, so to speak, kind of their version of an ARL. I get those, but there's nothing else that a special ed teacher could.
Not that we're comfortable with. Right now, we use something called the ABCTE testing for special ed, and quite frankly, with the feedback we received from districts, we'd prefer not to do that.
Okay, thanks.
Could they use LEA specific for special ed? I had that question this morning.
As it is currently written, yes, unless you wanted to change that.
Because that's a
LEA specific is this is associate
program?
No, LEA specific is a separate license. This is for an associate license.
Okay.
I know. I'll try to stick. I'll try to bring that up as I talk about the others.
That makes sense.
I have some other questions about special ed, but
I can't
let's get
imagine
through
why.
this first, and we'll. Yeah.
So that's the associate aspect. So it's focusing heavy on content, and then the professional educator license, which is the next section, still has content requirements. There's still competencies that must be met. You'll notice we're going away from the word coursework, and we want to talk about competence. That's a whole other conversation. But ultimately, the emphasis on the professional license, before you get that professional license, that you've met your pedagogical requirements. And one of those pedagogical requirements is a pedagogical performance assessment. Now, we're not proposing that the board adopt a single assessment. We're going to recommend that either the board or the superintendent, whichever you would prefer, adopt standards that an assessment must meet to be used. And then universities, districts, and charters can explore, they could create, they could choose and what they want to do. Ultimately, and then the last bullet is also important here, because this is something you've received a lot of feedback, and that is the difficulty in terms of how we move from licenses to license. How do you move from elementary to secondary? How do you move from secondary to special ed? Those kind of things. And so what this is saying is that if you hold a professional license area in one of those instructional areas, you've met the performance requirements for pedagogy. You don't have to do that part again. You still have to you might still have to take the content test. You might still have to meet the competencies, but ultimately, the pedagogical performance assessment, you do that once and you're fine.
And say that, for multiple.
To switch areas.
Areas.
Yeah, to switch areas. Because someone that's elementary wants to go into secondary or vice versa, those kind of things. And then finally, and this is where probably I have the most questions, the last section talks about how the state should deal with licenses issued by other jurisdictions, so other countries, other states, those kind of things. Ultimately, what it's saying is it's similar to what we're doing now, except on a couple of points. Number one, it's recommending that the board would then accept reasonably equivalent tests from other states. So doesn't necessarily mean that they have to take our test. If it's a reasonably equivalent test, and we'd have to, as staff, have to figure out, how that works. But ultimately, if it's a similar test, and you met that state's requirement, then we're good.
So we're up on that again. Reasonably similar test.
Yeah, what did I say on the thing?
No, you might have said this.
Reasonably equivalent.
Equivalent.
Yeah.
So does that go for both the pedagogy and and praxis?
Yes. So content test, pedagogy assessments, as long as it's reasonably equivalent and they've met the standard for the other state, then we're not going to make them do our version, if you will. And then ultimately, the last bullet sets a line where if you've been teaching for this long, you don't have to take those assessments because you've been teaching and been successful for that period of time. So that's the rule overall.
Travis, can I ask a question
Of
about
course.
that last one? So how do we know if they've been disciplined in another state? Is there a date? There's not a database that
There
says
is.
There is a big data.
So it's the NASDAQ. Essentially, when someone applies from out of state, one of the things we do is we run their name through the NASDAQ database. I don't know how else to name it, but to see if there's been any formal action. They also have to answer a question stating, so if they say there is, then we request all that specific information. And then ultimately, if they're going to show us that license from another state, we're going to verify it. We're going to, double check that it's not a forgery or something like that. I mean, those kind of things, typical things.
Okay, thank you.
So Travis, on that last bullet, if a person had 4 years in a district-specific license and he was successful, would he not have to take content or pedagogical assessments?
So this specific, that's open to your discussion. This specific section is talking about individuals holding a license from another jurisdiction.
Okay.
If they're utilizing a Utah license, this would not apply.
Okay. So
it's not intended to be a workaround for internal people. It's for people coming from other states.
Out of states or countries. Another related question to this, and I don't know if this would be in the rule, but one of the things that I've always found frustrating, and I've just recently heard of another situation, is that out of country people it's hard to do a background check. Would that be not addressed in this rule, or just we're going to ignore that for the time being?
Well, I can only guess at that frustration because it can stem from many different things. But ultimately, the conversation I have most often is an individual who does not have a Social Security number and wants to apply for a license, when ultimately we're saying you can't apply for a license until you have the right to work in the country. And so you have a chicken and the egg issue. There are people from outside of the country who want to get a license in Utah so then they can apply for a work visa. And we've said, no, you can't do it in that order.
But we've had hundreds of international teachers.
Maybe now the dual immersion, now they're on visas that we sponsor. And their background checks aren't an issue. As soon as they have a Social Security number, we run them through so that we're tracking them ongoing, like while they're here, all of that information.
But you can get background on them
absolutely. As soon as they've got a Social Security number, we might not have a records agreement with China, like we might not get something that happened when they were 8 years old, but at minimum we have anything from the states, and we're tracking them in those databases. So if something did happen, we would.
But you don't have anything if the person's 30. You don't have anything from when he's 25 in China.
That's true. That's true.
Okay, Travis, I think we're ready for the questions. If
you're
ready to.
So I've kind of alluded to a couple of these already. So if we want to scroll back up, Angie, if this is you up there. I think the biggest one, quite frankly, is at the beginning is the program approval, that deadline date that says that if you are enrolled in a program after January 1, 2019, those are the individuals that must meet the pedagogical performance assessment in order to be licensed, to get that professional license.
So a year from now.
Yeah. Yes, you're right. And this is when they enroll, not when they would complete. This is when they enroll in their program. Because universities have that struggle where they can't really change their program on people. But that's what that deadline would be.
First enrolled or enrolled period? First enrolled.
Enrolled in the it probably should be first enrolled in the program.
Yeah.
Because enrolling in a university is separate than enrolling in the education program.
Okay. Board members, do you have any questions about that date? Any concerns about it?
I'd like to hear what, you've had some meetings about this, call them whatever you want.
We really haven't discussed this much yet with universities. They may ask for it to be pushed back. They may not. I honestly don't know.
Do you have any sense of?
I think I'm going to get different answers from different universities.
Okay.
I think it's reasonable if everything's.
And it is just new enrollees. We're not, so.
Right, to the education.
Right.
Right. Okay.
The next question that I would have is regarding the LEA-specific license, because as you mentioned, there have been individuals that are concerned about that use of that for special education. But at the same time, if an LEA-specific is kind of the new version of an authorization, that there's going to be need for that sometimes. But ultimately, that's why the LEA-specific, has a variable length that the local board can ask for how long it is. So if it's a special ed person coming from out of state, they might say, well, we're just going to give it to you for a year, get your license in order. But ultimately, the other thing here, that the question point is, does the board want to hand on this? Does the board want to review these decisions that are long-term? Because the first, the idea was, so the first renewal, so they've had the license for 3 years. Does the state board want to be a check on that to say, should this be something that's continuing? That's an open question. I think it depends on who you ask.
Do you mean literally that these would come before the board for some substantive, or would it be in a laundry list of 200 people?
Well, I don't know how prevalent these would be, but if they become overly prevalent, it would be like the consent calendar right now. If there's only 20 of them, it may be more substantive.
Which is kind of ridiculous. I mean, it was kind of
And if the board doesn't want to do that, then we should strike that part of the language.
Okay, what do you guys think?
What about staff?
Excuse me, hold on a minute, Carol.
I thought I was one of you guys.
Elisa?
Oh.
Michelle?
I guess I'm not a you guy.
We need to give everybody the opportunity.
I don't know. I mean, I'd like to hear what the rest of the board thought about that. I could go either way.
Okay, Elisa, do you have input?
No, I don't. I think that this, I mean, I don't, it's difficult. I think it would be, I mean, the rest of the board has opportunity to send our committee information. Maybe we should reach out to ask them to look at it before the next meeting, but I don't feel like this is my area of expertise as much as other board members. And so I'm trying to,
Would another option be, hey, I'm a level 3 teacher. Yeah, don't.
Additional
Oh, okay. Would another option be to have the superintendent review it, or
yes,
something like that? So there'd be some review of it, but not necessarily. I just think it's going to be meaningless coming to the board if it's like letters of authorization.
It's possible.
I would think that too. I think that the board members aren't going to know enough to really.
Well, and there is a bullet, and I kind of skipped over this. There is a bullet here that asks that the superintendent act as the governing board for a private school, so that they can still receive these types of licenses. So there is a precedent there. You could say something that the first time you renew it, you have to have approval by the superintendent, and something like that.
Okay, I think that's a good idea. Do you guys have any? Okay.
Okay.
All right.
So the next question point really is under the, oh no, I got to find it. I think it's under the professional license, and that is the standards for the pedagogical performance assessment. Is that something the board wants to tackle? The board wants to adopt those standards, or do they want to designate that to the superintendent to establish? That's your decision.
Elisa, go ahead.
My opinion would be that we have the superintendent establish that, but we could review it.
Oh, certainly.
Okay.
I just have a question. I guess I don't know how exhaustive the standards would be, but one thing you could do is, depending on how you communicate that, or the superintendent, which would probably likely be the two of you with her, could, whatever that document that we establish with those standards, we could incorporate into the rule and just reference
like the
it.
special ed rule book.
Yeah.
Yeah.
So that might be a way.
I think that would be helpful
Yeah.
for the board to be involved a little bit, because we all know Sid, but Sid's probably not going to be here forever. So,
Unless we can figure out side org stuff.
Yeah.
Okay. Then the other thing, the last one I had, and then we can talk about anything you'd like, is on the out-of-state jurisdictions. Oh, now I remembered the other one. I'll come back to that. The 4 or more years of successful experience from other states. That's, let's just say that's somewhat of an arbitrary line. There's no research on this. Some people think 3, some people think 5, but other people think 10. So we just kind of said, well, 4 seems reasonable, but ultimately that's a pretty important line, because we're drawing a line that says you no longer have to take our assessments. That's pretty important.
And why did you use 4?
Because most people liked 3 or 5, and it was in the middle. quite frankly.
The other thing we've thought about for is that if you think about our current system where a level 1 lasts for 3 years and then into the 4th year, that would be like 1 year beyond that what currently would be the level 1. And we also just made it up.
Yeah. and kind of, do you know from state to state, is that a pretty common level 1 to level 2, or how
It is. I have not been able to find that it is consistent at all. Because there are many states that do what we do now. You have to take their test. And there are some states that say, we don't care what you took as long as you took it for your state. And so it's like all over.
And the reason I ask that is not just to, add another question, but because to me that would suggest that the person's a secondary level in another state, which suggests that there's been some scrutiny in those years.
And the way I've worded this as well is that it's licensed experience.
Yeah.
So this is experience after you've received your standard license, and it's 4 years, and that's usually 3 to 4 years is your induction period. So that's why we're saying if you've completed that induction period, we're just going to honor that essentially.
And I think that's, I would consider somebody kind of a veteran teacher if they've got 4 years. So 3, maybe not. So I kind of, I'm okay with the 4.
And then, I did remember the one I missed, and it is
Travis, before you go on, I just so we can go ahead and write the rule for 4. You're all good with that.
I think.
Okay.
You guys are good.
No,
I just wanted to be
not
sure.
hearing any concerns.
The other one was, quite frankly, is the length of the associate license. Yeah. You've received a lot of feedback on that. Currently, it's proposing to be written as 3 years with a 1-year extension. That's the one where we need you to tell us what you want us to do.
Lisa?
Could you just, I don't know all the feedback you've been hearing. Could you just give us some of the things that you've been hearing?
So, UEA has given public feedback in the letter to the board and about that. Ultimately, we want everyone to be in a professional license, and we agree with UEA on that. That's what we want. And so the question is, how much time do you give them to do it? We did 3 years with 1 year's extension as a compromise because we were thinking, well, 3 doesn't seem like it works all the time. 5 seems like too long, so we were kind of just going in the middle again.
And is that your experience using with other licenses that sometimes it takes
ARL,
time?
Most ARL, and that's the tricky part, is it's most versus the 1%ers that cause a problem. Because in our rules, we got to be careful of those really weird situations. But most people complete ARL in 1.5 to 2 years. And so most people going through APT, we don't know yet. They're required to teach for 3 years, but we don't know how long, they have to complete their stuff. University programs are typically 2 years long because it's usually your junior and senior year. So I think somewhere in the realm of 2, 3, or 4 is probably the most reasonable. Okay. But that's my personal opinion, I should say.
Talk to me about the extension thing. Who would grant the extension?
The extension would be requested only by an LEA. So currently under our board rule, you can get a 1-year extension on your level 1 license, but again, only if you're LEA. So if your LEA says, we're not comfortable getting you that professional license, but we think you're almost there, and so we think we want to keep you in a classroom. We want to keep working with you. So a person cannot request the extension on their own, but an LEA can.
Okay.
Okay. Any suggestions? Are you okay with 3 with a 1-year
I like
extension?
that. I can live with that. Let me put it that way.
Okay. Elisa, you okay with that?
Those are all the questions that I have.
Okay. I have a question for you.
Mm-hmm.
USEEP was here. Leah gave us USEEP's recommendations last time. And one of the things that they brought up was something that concerns me as well. And that is that we are putting, a lot of times general ed teachers will have special ed kids in their classrooms, inclusion, and have a very difficult time because they don't know how to manage them. And so I would like something, USEEP's recommendation was that we put something in here, whether it's a micro-credential or something, that they have some training that before they go into a classroom, so that they know how to handle a child who has a meltdown in their class or whatever. We see a lot of those kinds of things. I was talking to Ben Rasmussen. They're seeing more and more come through UPAC of general ed teachers who are just kind of at their wits' end with special ed teachers. And so special ed, did I say teachers? Yeah. Sorry, special ed students. We love our special ed teachers. Anyway, they're at their wits' end. So I would like to see something added in there, especially since they requested as well, that they get some training, whether it be a micro-credential, if you think that would be the best thing, or on special education. Now, some of them may have already had it. I know I had a lot of special education when I was in school, but that's because I am who I am, and I had, that's why I took it. But a lot of them probably haven't had anything.
So I want to clarify if you would want that to be part of the associate license or part of the professional, like where would you like that to land? And then also just to say, well, once we get this rule put together, there are associated rules. And one of those associated rules governs teacher preparation. And so that that's something we've already talked about. It's something we've been working on in our NTEP group again, is what would that look like? Because we'd like every teacher to be able to teach every student and know that every student can actually learn in those classrooms. And we're tired of the excuses of, well, I don't know how to teach those kids. And so we are definitely tackling that, but we could include it here as part of the criterion when you mentioned a micro-credential, but the question would be where.
Well, I'm thinking before, they actually encounter the problem. So that would be it there as an associate.
And my druthers would be to not only have it required for every teacher for the LEA specific as well. That if it's important if this is that crucial for every kind of teacher, then it ought to also be if it's a singular requirement or one of two for the LEA specific as well.
That's certainly something the board could direct us to do, because as of right now, the LEA specific has
no requirements,
minimal to no requirements. But if that's something you wanted as a board to establish, that's certainly within what you could do.
I agree. I hear of a lot of problems that are with general ed teachers dealing with special ed students.
Do you guys have any input? Sorry, other board members?
Can I give an update on where we're going to go from here then?
Yes, thank you.
So I think the next steps is ultimately we don't want to have a formal draft of this rule out to the public until after the full board's had a chance to look at this and made any changes or motions that they want to do. So we'll be waiting for that point. But in the meantime, we're still working on things like license renewal. Some of, as Diana mentioned, some of those other related rules, we're going to continue to work with those. And ultimately, once we do have a rule after the January meeting, the intention is to go out to a couple more stakeholders with the exact language of the rule to get feedback before February. I mean, that's what I'm crossing my fingers for. We'll see if it happens, but we're going to try to do that.
And all that is contingent on the legislature passing the statute that would allow us to do this.
Right.
Okay. Thank you very much. Thank you both.
Well, I had one more question then, just related to what you said. You would have the exact language of the rule, and it would be after the board's first reading that you would then
No, it would. So what would happen? So in January, the board is going to look at this as a whole.
Right.
And then based on whatever the board decides, we'll write a formal rule and take it out to stakeholders. And then when we bring it to the board for first reading, we'll have had those meetings. That's the goal. That's what we're trying to do.
Yeah, I think that would be great before it's even voted on for the first time. I would love to know.
So hopefully we would then have the rule for you plus the feedback that we got from the stakeholders in that meeting.
That would be good. I think it would be good to have a board study session too, so that they're.
Oh, absolutely.
Because we bring all of this, and we've had all the background, but then if you haven't had the background, you have lots of questions. So thank you very much for that. We appreciate you. We're going to go to public comment, and we're going to start with Tina, Jason, Sarah, and Rita. We have about 2 minutes for each one of you. Sybil is going to time you and let you know when your time is up. So thank you for coming, and if you can kind of just be ready one right after the other, that'll be great. And just know that this is, there'll be lots of other opportunities for feedback as well.
And I just wanted to thank Travis for this outline. It was very helpful in determining where the thought process was. And so I just had a couple quick questions as to consider. Will there be some process or some information shared about the transition between those that are currently in ARL and APT through this process? Has that been delineated anywhere? And how will that be handled? The other question I have, interested on what relicensure and returning educator, what that process would look like. That's a pretty big slice of individuals that would concern, and so interested in what that looks like. Question, how prescriptive is the intent of the board to be with regards to competencies, specific assessments? In the past, some things are very prescriptive, others are very vague. Do we have a sense of how prescriptive we want to be on a few of those items? With regards to the content knowledge of the associate license, in the elementary portion, it doesn't mention a bachelor's degree, and so, but it does in the secondary and CTE, and I was wondering if there was a specific reason why a bachelor's degree or higher with a major in the content area would not also be an acceptable content measure there.
Okay.
And there isn't, I know there's been talk of minors and what we do with minors and how that would play into, if they have a minor, would that be an acceptable content knowledge area? But I didn't see anything addressed for those items. I think that's all that I have right now. There's lots of specific questions that I can just ask Travis and or Diana about specifically.
Okay, thank you, Tina. Thanks for bringing those up. We appreciate it.
Jason Stanger again, Executive Director of InTech Collegiate High School. One thing that we've been concerned about over the years is that existing teachers with full licenses are not able to get ongoing authorizations when we could give someone with eminence an ongoing authorization to do some things. And it appears that that's been, or is being considered to be resolved here, that we can attach LEA-specific endorsements to associate and professional licenses, and that is very important for small schools, whether they're charters or rural schools. So whatever version comes out, we really advocate for allowing LEA-specific endorsements to be attached to all levels of licenses, which hasn't been the case in the past.
Okay, thank you very much, Jason. Sarah?
Good morning, Sarah Jones with UEA. You saw our list of substantive comments, so I won't go into detail on those. If you have any questions about that, please let me know. I'll just highlight two things that I really didn't hear come up in the discussion today. One is the lack of qualifications for the LEA-specific license. The only qualification at this point is a background check, not even an educator ethics review, which the other licenses have. So I think the board needs to really consider what are those key things that, regardless of whether it's administered or an LEA-specific license or anything else, what are those key things that someone needs to know to be qualified to go into a classroom before they're licensed? And I think those qualifications they're not there right now. The second thing I'll point out on the associate license is that essentially the associate license, as it's currently drafted, and you're going through this discussion process right now, is APT, meaning that the only difference, besides the name is different, is the addition of a micro-credential. So APT required background check, ethics review, content test, bachelor's degree. Those were the substantive things. The associate license requires background check, ethics review, content test, bachelor's degree, or skill certification. The only substantive difference is a micro-credential. So is that really all it takes to be ready if you're alternately prepared? Because I'm not talking about the traditionally prepared people enrolled in a university program. And the addition of a special ed qualification, that's critical. Knowing what the Utah teaching standards actually say, knowing what the core academic standards are, not just passing a praxis test, having some classroom experience, all of those things, those are pretty critical. And right now it's just a proposal that it's a micro-credential. And a micro-credential, it's defined very differently, kind of depending who you talk to, could be as little as 10 hours of time. So those are our big concerns right now.
Thank you, Sarah.
Okay, Rita.
Hello, Rita Hegren with AFT. Going through the points quickly. Under the license levels, the associate license for 3 years with 1-year extension. We're a little uncomfortable with that because a lot of out in the trades and other professions, it's usually a 2-year license. And so I think that most principals and teachers know after 2 years if they should stay in the classroom or not, with a 3rd year as an option. I'm aware of a situation where a principal didn't like a teacher and so made them take a 4th year, the 3rd year to the 4th year, as a punishment, as a retribution. So we've got to get away from those possible situations. But looking over at the, excuse me, the renewal for the LEAs, how do you determine whether it's 1, 2, or 3 years, what they're going to ask for? Now, I could see a dance teacher or a woods teacher coming in out of industry. They obviously have the skill set. I can see doing a 3-year license for them. But then you also have, with special ed coming in somewhere else from another state, you talked about, get a 1-year license until they can complete the Utah license. But it's possible also that the principal's younger brother is teaching a class that he's not qualified for. And that because, this is the nepotism issue. And at no point on the LEA, on the renewals, do they have to show any demonstration of pedagogy or content knowledge. Okay. So this could turn into a perpetual situation where someone who's never actually demonstrated to the state, to the State Office of Education, the State Board of Education, that they're competent to teach our children. Again, it's holding everybody to a high standard, giving them a chance to get there. But I think it needs to be reviewed. And again, go 3 years. You got someone that's teaching woods coming in. Hey, that's good. They're not having any problems. There's no discipline problems. There's no ethical issues. Go ahead and renew. But it needs to be looked at so it's not a perpetual, thank you. It's not a perpetual license without any review of any type. Thank you. There's more, but yeah.
Thank you. There will be more opportunities. So.
Thank you.
Elisa.
If any of you write in your comments, then we can, you can do that anytime so we can see those also.
Yes, that's a good point. Written comments are always appreciated. And if we can get them before board meeting starts. I know we get a lot of written comments during Thursday and Friday board meetings, but we're so busy it's hard for us to read them. So if we can get them before, then that's very, very helpful. So, okay, I need one more motion.
I motion that we adjourn.
Okay. There's a motion to adjourn. All in favor? Aye. Okay. It's unanimous. Thank you.